The House Committee on the Judiciary will come to order. Without objection, the Chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's hearing on digital dragnets, examining the government's access to your personal data. Before we begin, I'd like to remind members that we have established an email address and distribution list dedicated to circulating exhibits, motions, or other written materials that members might want to offer as part of our hearing today. If you'd like to submit materials, please send them to the email address that has been previously distributed to your offices, and we will circulate the materials to members and staff as quickly as we can. I'll now recognize myself for an opening statement after observing that the proceeding was probably not known when Bob Goodlatte was chairman of this committee before we went into all this stuff. Data is often called the oil of the 21st century, and the rush to participate in the market for data has made the tracking of our personal information an inescapable part of daily life. From web hosts and cell phones to service providers and mobile applications, companies that provide online services are part of an ever-growing industry around the collection and commodification of our data. Private companies now compete with each other to manage these enormous troves of information, and this trend alone presents significant privacy concerns. But it's even more troubling that law enforcement and intelligence agencies at all levels of government are purchasing this data for their own use, often sidestepping protections designed to limit the direct acquisition of the exact same information. Simply put, law enforcement and intelligence agencies are now able to obtain vast quantities of information without a warrant. Your physical location, your personal habits, your internet searches, your likes and dislikes, and your politics, to name just a few private concerns, are all available and accessible to the government. The easy availability of personal data to the government poses significant risk to minorities, to those with unpopular views, to our system of justice, and ultimately to the stability of our democracy itself. Our founders understood what a country without protection from unwarranted search and seizure looks like. They knew that to protect the citizens of the fledgling United States of America from the government it was creating, it was essential to provide basic guidelines for law enforcement to follow, which they did in the Fourth Amendment. The recent advances have allowed the technology of data collection to get ahead of the laws protecting our privacy. This overreach is clear from recent scandals that include the pervasive use of geolocation data to track peaceful protesters, the sweeping surveillance of thousands of devices to identify just 2 suspects, and the purchase of data from prayer apps and dating apps. What links these incidents and others together is a disturbing trend: the increasing reliance of law enforcement on massive data sets with little consideration for due process. It is, plain and simple, the warrantless surveillance of everyday Americans, and it may have dire consequences. For example, women across the country who wonder what America will look like in the wake of the Dobbs decision are at particular risk for this data surveillance. In states where abortion is now a crime, law enforcement can use available data to keep track of who searches online for the words miscarriage or abortion. They can purchase geolocation data to monitor which phones travel out of state to go to a medical provider. They can access the data from tracking apps or purchase integrated data profiles to see or even predict if and when a woman may be pregnant or may be likely to seek an abortion. The more we learn, the more we realize that there are few measures in place to shield our digital footprints from the hands of government agencies. Every person sitting in this room likely has a cell phone with them today that is tracking location, use, and communications to and from the device. Private companies will sweep up that information, package it, and sell it for uses ranging from the most benign micro-targeted advertisement to the most invasive digital profile. Law enforcement and intelligence agencies clearly have an interest in those commercial products, especially where due process concerns would make it difficult for those agencies to acquire the data directly. Although some companies claim to sell only anonymized data or never to sell to the government, experts agree that both guarantees are empty promises. When there is no constraint on the future use or sale of individual data, companies have no control over re-identification of that data and no control over where it goes next. Although we do not know the full scope of the federal government's access to and use of these commercial products, some government contracts give us a sense of scale. For example, ICE, the DEA, and the FBI each contract with a data broker that sources location data from over 80,000 apps. The products are so precise that officers can track individuals within specific homes and businesses. Again, tracking your location over time, within inches, without any due process whatsoever. And the problem is not limited to the purchase of data. So-called reverse search warrants allow law enforcement agencies to make broad requests for a company's data, such as every person who searched for a specific term or every person who was in a particular place over some period of time, totally upending traditional notions of a narrowly tailored warrant based on probable cause. The end result is that just by going about your daily life, your data may be swept up in and make you the subject of a criminal investigation. Investigations this broad and baseless present significant risk of mistaken identity and have led to erroneous arrests in many cases. If law enforcement and intelligence agencies remain unrestrained in their ability to purchase this data, our right to privacy will be at best illusory. I look forward to hearing from our distinguished witnesses about how pervasive this problem is and how we can best rebalance the law to protect our liberty. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. I want to thank you for having this hearing and for our witnesses, all of our witnesses who are here today. I look forward to their testimony. Over the last year, we've seen how big government has threatened almost every freedom Americans enjoy. And just stop and think about it for a second. The First Amendment rights we enjoy, your right to practice your faith, your right to assemble, right to petition the government, freedom of press, freedom of speech, every single one has been attacked, has been assaulted over the last year by government. Until a few months ago, there were still places in the country where a full congregation couldn't meet on Sunday morning. Your right to assemble. And I always use the example, about a year and a half ago, I spoke to the New Mexico Republican Party in Amarillo, Texas, because they had to go to Texas for the freedom to assemble and meet in the size group that they wanted to meet. Ability to petition your government, again, until a few months ago, American citizens couldn't even go into their capital to talk to their member of Congress to petition them to redress their grievances because the Speaker of the House wouldn't let them in. And we know what's happened with freedom of press and freedom of speech. I mean, the government was trying to, they did for like 3 weeks, then thank goodness they canceled it. They tried to form a disinformation governance board, for goodness sake. So First Amendment attacks we've seen. We know about the Second Amendment attacks. There's going to be one tomorrow in this committee, a markup on a bill to limit the Second Amendment rights law-abiding Americans enjoy. And of course, today the focus is on our Fourth Amendment rights. Never before in our history has the government known more about its citizens and had more sophisticated tools for spying on us than right now. Not only does government have the technological abilities to gather large amounts of information about us, but the law is also in many ways outdated and on the side of those doing the spying rather than on those being spied on. This is wrong and it's un-American. The Foreign Intelligence Surveillance Act was originally intended by Congress to rein in abuses from the intelligence community in the 60s and 70s. FISA grew out of the Senate Church Committee investigation, which uncovered, among other things, that the CIA was infiltrating political organizations. But over time, what were supposed to be guardrails have turned into loopholes for legitimizing a surveillance dragnet. Nowhere was this more obvious than when the FBI Director Comey and his cronies misused the FISA program to target a presidential campaign. It took years for us to uncover the systematic abuses that allowed Comey and the FBI to spy on an American president. And if the FBI can do it, and this is critical, the FBI can do it to a presidential campaign, they can do it to anyone, any American citizen. But still, FISA remains broken and in desperate need of serious reform. It is our hope that Congress will be ready soon to move serious legislation to stop these abuses and provide for more transparency and accountability in the FISA process. And the problem is hardly limited to FISA. The mass adoption of electronic devices that collect data on every aspect of our lives has allowed new avenues for surveillance that require us to rethink the law. I want to thank former Chairman Goodlatte for joining us today. Among other things, Chairman Goodlatte shepherded through much-needed reforms to the Electronic Communications Privacy Act, or ECPA, excuse me. That reform legislation was reported out of this committee and passed the House twice. Unfortunately, did not get through the Senate. It's high time that Congress reform that law. This should be low-hanging fruit to protect Americans' privacy. That legislation is woefully outdated. It was signed into law in 1986 before the modern internet existed, and it has left many loopholes for warrantless surveillance that are regularly exploited by law enforcement. Earlier this year, this committee sought to close one such loophole when we passed legislation to put restrictions on gag orders that prevent third parties from telling their customers that their information is being solicited by the government. But we still have much work to do. This must include us taking a hard look at government's warrantless access to commercially available bulk data and its use of tools like Pegasus that allow them to spy on encrypted mobile devices. It should also include us considering restrictions on the government's use of facial recognition technology within the United States to target citizens. I hope that we can work together and we can begin the long overdue process of putting common sense guardrails in place to protect Americans' Fourth Amendment liberties. Mr. Chairman, thank you again for this hearing, and I do look forward to the discussion and the testimony from our witnesses.
Thank you, Mr. Jordan. Without objection, all other opening statements will be included in the record. I will now introduce today's witnesses. Bob Goodlatte is Senior Policy Advisor for the Project for Privacy and Surveillance Accountability and is also the former Chairman of the House Judiciary Committee, that is to say of this committee, as well as the former Chairman of the House Agriculture Committee. Chairman Goodlatte served in the House with distinction from 1993 until 2019. He received his BA from Bates College and his JD from Washington and Lee University. It's our great pleasure to welcome him back to this committee. Sarah Lamdon is a professor of law at the City University of New York School of Law, whose research focuses on information law and policy. She's also a fellow at the Engelberg Center on Innovation Law and Policy at NYU School of Law. Professor Lamdon received her undergraduate and law degree from the University of Kansas and a master's degree from Emporia State University School of Library and Information Management. Rebecca Wexler is faculty co-director of the Berkeley Center for Law and Technology and assistant professor of law at the University of California, Berkeley School of Law. Prior to attending law school, she made documentary films for National Broadcast Television, museums, and educational distribution. Professor Wexler received her BA from Harvard College, a Master of Philosophy from Cambridge University, and a JD from Yale Law School. Brett Tolman serves as Executive Director of Right on Crime. He is also the founder of the Tolman Group, focusing on public policy and government reform. Prior to entering private practice, he served as the United States Attorney for the District of Utah. Previously, he also served as Chief Counsel for Crime and Terrorism to the United States Senate Judiciary Committee. Mr. Tolman received his undergraduate and law degrees from Brigham Young University. Elizabeth Goiteen, and I hope I have that pronunciation right, Elizabeth Goiteen is Senior Director of the Liberty and National Security Program at the Brennan Center for Justice. Before coming to the Brennan Center, she served as counsel to Senator Russ Feingold on the Senate Judiciary Committee and as a trial attorney in the Federal Programs Branch of the Civil Division of the Department of Justice. Previously, she clerked for Judge Michael Daley Hawkins on the U.S. Court of Appeals for the Ninth Circuit. She received her undergraduate and law degrees from Yale University. We welcome our distinguished witnesses and we thank them for participating today. I will begin by swearing in our witnesses. I ask that our witnesses in person please rise and raise your right hand. I ask that our remote witnesses please turn on your audio and make sure I can see your face and raised right hand while I administer the oath. Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and beliefs, so help you God? Let the record show that the witnesses have answered in the affirmative. Thank you, and please be seated. Please note that each of your written statements will be entered into the record in its entirety. Accordingly, I ask that you summarize your testimony in 5 minutes. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, it signals your 5 minutes have expired. For our witnesses appearing virtually, there is a timer on your screen to help you keep track of time. Chairman Goodlatte, you may begin.
Chairman Adler, Ranking Member Jordan, I'm honored to be back before my colleagues today. I come as the Senior Policy Advisor for the Project for Privacy and Surveillance Accountability, or PPSA, a nonpartisan group that advocates for our Fourth Amendment protections and government surveillance reform. We work on a daily basis with about 10 other civil liberties organizations across the ideological spectrum. A giant loophole we never imagined has weakened those protections. Government agencies are asserting they can flout the Fourth Amendment's requirement for a probable cause warrant by simply buying our personal data. Agencies ranging from the Defense Intelligence Agency to the IRS to likely the FBI and CIA as well are buying the personal data of millions of Americans they would otherwise have to get a warrant to obtain. Some of us are nonchalant about all of the personal information companies like Facebook compile on us. Others are outraged at this corporate invasion of our privacy. I would add, however, that the extraction of our personal data by the government is far more ominous. No private party can break down your door at dawn, take you out in handcuffs, and prosecute you. No private party can fine you, enjoin you, restrain you, tax you, and deprive you of liberty and, yes, even life. Only the government can do that. Our very country was born out of anger and fear of what a government can do to people when it doesn't respect their privacy. The offensiveness of seizures of Americans' personal information by agents of the British Crown explains why the framers of the Constitution explicitly required a warrant based on probable cause. Now, government lawyers are embellishing this work of the framers by adding, quote, unless we buy it, end quote. This practice defies the Fourth Amendment. It also defies Supreme Court opinions requiring warrants to access someone's location history from a cell tower and forbidding warrantless intrusion into a cell phone because it holds, quote, the privacies of life. A reasonable interpretation of these opinions should have prompted government lawyers to tread lightly. Instead, like a flippant teenager, government lawyers take these restrictions as a sign that anything not expressly prohibited must be permissible. Thus, Senator Ron Wyden reports that the Defense Intelligence Agency informed his office it does not have to adhere to the Constitution or the Supreme Court Carpenter ruling when it buys data. That is outrageous. Even more outrageous is how data purchasing operates in practice. Just yesterday, the American Civil Liberties Union released thousands of pages of data showing that Department of Homeland Security agencies are paying millions of dollars to data brokers, one of which claims to collect more than 15 billion, that's with a B, location points from over 250 million mobile devices every day. The Department of Defense, for example, has used this tactic to access data from a dating app, Muslim Mingle. Imagine this government agency managed to compromise the Fourth Amendment and degrade the First Amendment, right to free exercise of religion, in just one move. In February, Senators Wyden and Heinrich revealed that the CIA is engaged in bulk collection based not on a statutory authority, but on Executive Order 12333, entirely outside of any judicial or statutory authority. This strongly suggests legal acrobatics similar to DOD's are at play at the CIA. Under current law, the government cannot obtain records from companies like Facebook and Google without a court order. Why should data brokers be treated any differently? The obscurity of the loophole the government is exploiting underscore how shaky its legal foundation is. The solution is, I suggest, the Fourth Amendment is Not for Sale Act. This bill would close the loopholes in the law. It would forbid government agencies from buying personal data. It would otherwise need a warrant or subpoena to obtain. When the Fourth Amendment is Not for Sale Act passes, U.S. law enforcement and intelligence agencies will still have powerful legal tools at their fingertips with which to follow leads that can catch terrorists, spies, and dangerous criminals. They will just have to follow the rules. I thank Chairman Nadler and Congresswoman Lofgren for their leadership in introducing this legislation. I also thank Ranking Member Jordan, who has expressed concern about the impact of the surveillance state on Americans' fundamental liberties and rights. Many members on both sides of the aisle on this committee and in the Congress as a whole have spoken out. Now it's time to act. The more answers you can compel from the government about the scope and uses of purchased data, the better we will be able to devise rules to protect the American people from lawless mass surveillance. Thank you.
Thank you, Chairman Goodlatte. Professor Lamdon, you are now recognized for 5 minutes.
Chairman Nadler, Ranking Member Jordan, and distinguished members of the committee, I thank you for the opportunity to speak here today about the government's use of personal data. Surveillance has always been a part of U.S. national security and public safety regimes, but traditionally, policing and intelligence work revolved around the compelled and targeted surveillance, traffic stops, particularized warrants, and other searches done on a person-by-person basis. These compelled surveillance methods are being replaced by voluntary surveillance method systems that are data-driven, like automated license plate readers and Dragnet reverse location and keyword warrants. People call these datafied surveillance systems voluntary, but most of us don't truly volunteer to be a part of them. We may technically consent to driving on a public road lined with cameras or clicking I agree to access an online service. But these choices to trade our data for access are illusory. We must make them in order to participate in daily life. Every move we make online, including through the apps on our phones, connected home electronics, and wearable devices, generates data that can be collected, shared, and sold. Even when companies promise that they will anonymize our data, that data can easily be re-identified. In some cases, the government doesn't collect its own data or build its own data analytics systems, in most cases. Several types of companies comprise our modern surveillance infrastructure. First, we have data analytics systems and products. So those are algorithms, machine learning systems, and other forms of artificial intelligence that predict whether someone will commit a crime or default on a loan, et cetera. The second type of company is a designer data company, like a facial recognition or biometric data company, or a geospatial or geolocation data company that can pinpoint where you're located. The third type of companies are data brokers that provide huge dossiers containing information like our addresses, our work, and our credit histories. Together, these companies have become de facto primary fact finders in many law enforcement investigations. They've been called Big Brother's little helpers because they turn policing from a suspect-focused search into a constant, intrusive surveillance system that surveils all of us. Rather than focusing on particular suspects, data policing tools are dragnets, sifting through all of our data. They provide a 300-degree view of our lives, revealing where we go, who we know, and what we do each day. The data company's services likely know more about you than your friends or family do. Even if you try to opt out of data collection, the companies create shadow profiles about you based on the data that your friends, family, and associates trail behind them when they go online. The data in these companies' products contain errors that are difficult, if not impossible, to correct, and the data analytics systems themselves are notoriously inaccurate. Without oversight and supervision, it is hard to figure out exactly how the government uses data analytics products. This obscurity flouts freedom of information laws. Legal loopholes put the industry beyond the scope of due process protections that are built into our laws and administrative procedures. Some legal experts posit that the government agencies do their work through these companies intentionally to buy their way around due process requirements. Without legal safeguards, there is no limit on what kinds of surveillance products agencies use and how they use them. Agencies don't monitor how employees use the products, so employees use the systems to make questionable searches. The government's partnerships with data companies are ripe for legislative oversight. Laws should require that the public be notified about how and why their data is being collected and used. These notices should set specific purposes and timelines for data programs. The programs should be audited regularly to be sure that they are being implemented for their intended purposes. Programs that use personal data should be transparent and provide for public comment. People should be able to consent to the collection of their personal data and to see and correct their data sets, even when those data sets are provided by a third party. There should be processes to ensure that when the government implements data programs, it is using accurate data and unbiased data analytics systems that properly serve their assigned purposes. As the government continues to work with data companies to build its surveillance infrastructure, we must balance the need for robust national security and public safety and the benefits of quick and easy data services with the privacy and civil rights of the American public. I look forward to answering your questions.
Thank you, Professor Lamdon. Professor Wexler, you're now recognized for 5 minutes.
Mr. Chairman and members of the committee, my name is Rebecca Wexler. I'm an assistant professor of law at the University of California, Berkeley School of Law. I'm honored to have been invited to testify today about how law enforcement collection of data through private intermediaries can conceal evidence of innocence by circumventing criminal defense discovery rights. Collecting data from private intermediaries rather than seizing it directly not only allows law enforcement to collect more information more easily. An underappreciated aspect of this practice is that it also allows law enforcement to collect less evidence of innocence. And when law enforcement does not possess exculpatory evidence, it can be much harder for the defense to access it, risking wrongful convictions. Let me give some examples. When law enforcement purchases data from intermediaries, or uses private biometric databases, or licenses surveillance software from private companies, the officers can stay ignorant of flaws in the data. They don't have to learn whether the data were acquired in violation of a privacy statute, or through breach of contract, or through unlawful hacking. They don't have to learn about errors in quality control that could have corrupted the data, or rendered it unreliable or subject to tampering. They don't have to learn about bugs or improper validation studies or racial and other biases in the software used to acquire the data. Indeed, private companies sometimes claim this type of information is a trade secret, and they refuse to disclose it even to their own law enforcement customers, much less in response to a subpoena. Yet all that information could be exculpatory evidence relevant to prove innocence and stop wrongful convictions. If law enforcement seizes data directly, they're much more likely to know these flaws because they will collect the data closer to its point of origin, or they will build the database or surveillance software directly. If they acquire data from private intermediaries, they're much more likely not to know because they can acquire the final data output without any other information. And when law enforcement is ignorant of flaws in their data or in data collection methods, it's harder for defendants to access that exculpatory evidence. Here's why. If law enforcement is ignorant of exculpatory evidence, defendants' constitutional Brady due process rights, which, as you know, would otherwise require the prosecution to disclose evidence of innocence, do not apply. Defendants' statutory discovery rights to obtain exculpatory evidence from the prosecution do not apply. And if defendants exercise their Sixth Amendment rights to call law enforcement officers to the witness stand, cross-examination will be futile. Meanwhile, current evidence rules permit prosecution witnesses to introduce data into evidence, even if they're ignorant about flaws in the data or the method of collecting it. Nor is it easy for defendants to get information about such flaws directly from a private company. In a catch-22, defendants can't subpoena companies directly for exculpatory evidence unless they already know the evidence exists and can identify it with specificity. That's a task that's virtually impossible for evidence you've not yet seen. And trying to get criminal defense subpoenas enforced across state lines can be prohibitively costly and time-consuming. Further, vendors of surveillance technologies sometimes say that their products are for law enforcement customers only and refuse to give or sell copies to criminal defense experts for scrutiny and testing. Indeed, some companies even refuse research licenses to independent scientists to scrutinize their products, all the while claiming in court that those products are subject to peer review. In sum, it's much harder for criminal defense counsel to access exculpatory evidence about flaws in data collected through private intermediaries, as opposed to data collected by law enforcement directly. To help fix this problem, Congress should consider ways to protect defense counsel's access to exculpatory evidence. For instance, eliminate the trade secret evidentiary privilege for private entities that sell data and investigative software to law enforcement. Clarify that the Stored Communications Act does not block criminal defense subpoenas to technology companies. Strengthen defendants' general third-party subpoena powers and require law enforcement to obtain exculpatory evidence on behalf of the accused if defense counsel is unable to obtain it directly. Thank you for the opportunity to testify today. I look forward to your questions.
Thank you, Professor Wexler. Mr. Tolman, you are now recognized for 5 minutes.
Thank you, Mr. Chairman Nadler, Ranking Member Jordan, and members of this committee, and thank you for the opportunity to testify today. I'm encouraged by the committee's decision to hold a hearing to address concerns around law enforcement's warrantless access to commercially available bulk data. These concerns are valid, and I share them. The Fourth Amendment affords Americans an expectation of privacy with respect to their person and property, such that if law enforcement wishes to gain access to their personal records, they must first establish probable cause to search, to secure a warrant, which they make available to the individual subject to search. The Supreme Court has ruled that a person's expectation to privacy under the Fourth Amendment follows them, not a particular location. But what about an individual's digital footprint? Is there a reasonable expectation of privacy attached to bulk records containing an individual's digital record? Yes, and as such, the Fourth Amendment demands a warrant predicate to access this information. The constant evolution of technology and the digital footprints that individuals generate as a result expose opportunities for end runs around the Fourth Amendment's privacy guarantees. Therefore, use of technology by the government upon its citizens must be subject to constant scrutiny. To that end, I am critical of the law enforcement practice of purchasing databases in bulk, which they then mine, or dare I say search, for incriminating information against unwitting citizens as violating the expectation of privacy guaranteed under the Fourth Amendment. This access by law enforcement of an individual's digital records and movements is purchased rather than obtained by a warrant as required by the Fourth Amendment. Americans' personal data is sold to law enforcement unbeknownst to them and for the purpose of investigating or surveilling them. This is a violation, plain and simple. Congressional attention and oversight concerning the lack of transparency and basic information relating to law enforcement's access to an individual's digital movements must persist to ensure the rights of citizens are not sacrificed on the altar of technological innovation. Private technology companies that contract with law enforcement harvest billions of photos posted by unsuspecting users on platforms such as Facebook, YouTube, Venmo, TikTok. This collection and data grab amounts to unprecedented invasions of privacy that places enormous undue control in the hands of the government and big tech, two entities not always known for their light touch or responsible use of power. Just because law enforcement collects the data from a third party that maintain the same for commercial purposes does not negate one's reasonable expectation of privacy when the data tracks their movement and location. Inevitably, law enforcement will default to reliance on unfettered access to digital records from third parties if permitted to bypass a warrant. They may do so touting laudatory uses, such as identifying missing persons, but a right abused for any reason is still an abuse, and its expansion in use is inevitable. Our founding fathers deliberately and prudently enshrined in the Bill of Rights prescriptions on the wanton search of Americans as a necessary bulwark for freedom. It is hard to square these notions and protections with the unfettered access to digital records that can instantaneously reveal an individual's identity, location, communications, movements, associations, and otherwise. Americans have long prided themselves on our ability to refuse the government unless it has legitimate cause to interfere with our liberty. Our police, at least in the absence of reasonable suspicion of wrongdoing, are supposed to rely on the consent of the citizenry in their interactions. The unfettered power to mine personal information with little public awareness or transparency stands this principle on its head. Law enforcement has already accessed all of the information needed to track them. Americans are placed in a position where they must choose between the convenience and necessity of technology against their right to privacy from government surveillance. Furthermore, we cannot ignore the risk that access to commercially available digital records without a warrant will be used to target certain Americans. Consider the chilling effect if the government could sidestep the probable cause necessary to obtain a warrant from the court and simply purchase the data necessary to target an American or groups of Americans for surveillance. What protections are in place to ensure that targets are not politically motivated or otherwise motivated in support of an agenda having nothing to do with public safety? Not long ago, I was tasked with leading the effort in the Senate to reauthorize the Patriot Act. We heard similar assurances years ago by those leading the Department of Justice and the FBI about FISA and those surveillance authorities not being turned against honest Americans. We have seen how that worked out as outlined in the recent and disturbing Inspector General reports. One needs only to look no further than Russia's and China's unconscionable and unfettered control over the digital footprint of its citizenry, where no expectation of privacy exists, to appreciate the limitations the Fourth Amendment places upon government agencies in America. Significant restraints are necessary for privacy protections to catch up to the rapidly advancing capabilities of technology. Americans deserve transparency as to the nature of law enforcement's access to data held by third parties, containing information for which they had a reasonable expectation to believe was private. Thank you once again for the opportunity to present these concerns to the members of this committee.
Thank you, Mr. Tolman. Ms. Goitin, you are now recognized for 5 minutes.
Chairman Nadler, Ranking Member Jordan, and members of the committee, thank you for this opportunity to testify. It's often said that the law fails to keep up with technology. When it comes to the government's access to Americans' personal data, that is an understatement. Advances in technology have rendered old Fourth Amendment doctrines obsolete and have opened up enormous gaps in the laws passed by Congress. The government is exploiting the resulting legal loopholes to obtain Americans' most sensitive information without a warrant, subpoena, or any legal process whatsoever. Let's start with the Fourth Amendment. Decades ago, the Supreme Court held that people have no Fourth Amendment rights in information they voluntarily share with a third party, such as a phone company. Whatever merit the so-called third-party doctrine had in the 1970s, it makes no sense in the digital era. Today, it's virtually impossible to go 24 hours without disclosing highly sensitive information to a multitude of third parties. Our internet searches and the websites we visit are logged by internet service providers. Our cell phones record our movements throughout the day, revealing visits to therapists, doctors, or houses of worship. Every online purchase creates a lasting digital record. The Supreme Court has finally begun to catch up. In 2018, the court held in Carpenter versus the United States that the police need a warrant to collect a week's worth of cell phone location information, even though customers share that information with the phone company. The court reasoned that this information can reveal the most intimate details of someone's life, their associations, habits, even beliefs. Moreover, there's really nothing voluntary about sharing this information because cell phones are not optional in modern society. Despite this ruling, investigative reporters have discovered that federal agencies have secretly been paying data brokers to gain access to vast troves of Americans' personal data, including cell phone location information. Agencies that have bought such data include the FBI, DEA, the Department of Defense, and as confirmed by thousands of pages of FOIA documents released by the ACLU yesterday, the Department of Homeland Security. Even the IRS, according to the Wall Street Journal, purchased access to a database containing millions of, or location information for millions of American cell phone records. Given the Carpenter decision, how can the government obtain Americans' geolocation information, sometimes in massive quantities, without getting a single warrant? It turns out agency lawyers have interpreted Carpenter to apply only when the government compels companies to disclose data. When the government merely incentivizes such disclosure by writing a big check, the warrant requirement just disappears. This is legal sophistry, but realistically, it could take years for the courts to settle that question. That leaves us for now with statutory protections. The Electronic Communications Privacy Act prohibits providers of communications and computing services from disclosing customer information to the government without a court order or a subpoena. But the law is woefully outdated. The companies it covers do not include many app developers or digital data brokers. It's not that Congress chose not to include them. Those entities simply didn't exist in 1986 when ECPA was passed. This gap creates an easy end run around the law's protections. Companies that are prohibited from selling their data to the government can sell it to a data broker instead, and the data broker can turn around and sell the same information to the government at a handsome profit. The information is effectively laundered through a middleman. Many app developers can sell geolocation data directly to the government, although in practice, they usually operate through data brokers as well. Easy government access to Americans' Fourth Amendment protected information doesn't just violate our privacy. It invites abuse, in particular, the targeting of people or groups based on race, religion, or political activity. We've seen this already. The Department of Defense purchased access to geolocation information from popular Muslim prayer and dating apps. Police departments used a data broker to track people who attended racial justice protests in Ferguson and Baltimore. It's time for Congress to step in. Chairman Nadler and Representative Lofgren have introduced the Fourth Amendment is Not for Sale Act, which would prohibit law enforcement and intelligence agencies from buying data that they would otherwise need a warrant or a subpoena to obtain. The Brennan Center supports this legislation, and we urge this committee to advance it quickly. Thank you, and I look forward to your questions.
I thank all the witnesses for their testimony. We will now proceed under the 5-minute rule with questions. I recognize myself for 5 minutes. Professor Lamdon, in your opening statement, you mentioned that personal data is combined into dossiers for government use and for integration with designer data companies specializing in data products. How does personal data flow to larger brokerage firms, and how is it combined into marketable packages for law enforcement and government entities?
So there are a series of different pathways. There's no one way that these data sets get into these dossiers, but there are major companies that collect data from over 10,000 sources. And those companies began as public records collectors. So they would collect things like DMV rolls, voting rolls, public records that were already available and accessible. And then they just kept kind of accumulating more and more sources, kind of to what Elizabeth just mentioned about how if the government wants to get data from a particular entity or a particular app or particular, data company or source, rather than selling it directly to the government, if the company or the app or whatever the entity is sells it to one of these major data brokers like a LexisNexis or an Oracle or one of these large data dossier companies, then those data dossier companies will license data streams to the government agency that contracts with them. So that's kind of how our personal data from, say, using Facebook or using the GPS on our phone makes its way to the government. It gets collected piece by piece and then placed in a large data dossier associated with your name.
Thank you. Professor Wexler, in cases where prosecutors fail to collect Brady information, what prevents the defense counsel from simply purchasing potentially exculpatory evidence from data brokers themselves?
Thank you for the question, Chairman Nadler. Beyond financial barriers and the possibility defense counsel might not know exculpatory information exists, like flaws in the data collection method, some companies refuse to sell data or investigative software to anyone other than law enforcement customers. So they just flat out say no. In addition, data companies don't generally sell information about flaws in their methods. They're likely instead to claim that information as a trade secret and refuse to even disclose it subject to a subpoena. Finally, some privacy statutes, including the SCA as interpreted by the courts today, bars private entities from disclosing some information to defense counsel, even if there is a subpoena and a court orders that the information is necessary to the administration of justice.
Thank you. Chairman Goodlatte, there is a disturbing lack of transparency when it comes to how Americans' detailed personal information reaches law enforcement or the government, whether it's through data broker purchases or geofence warrants. Are law enforcement and the federal government buying their way around due process protections? And do you believe that was the intention of the Electronic Communications Privacy Act when it was first passed?
I don't think the Electronic Communications Privacy Act, when it was first passed, contemplated this being an issue at all, since at that time, access to information in emails was probably the primary thing that could be obtained. And as has been mentioned, the evolution of the internet has been so dramatic since then that automatically information of all sorts is being gathered, and people don't even realize how much information is gathered. I counted yesterday that I have 160 apps on my phone. Probably half of those are tracking various pieces of information about me that's being stored somewhere and it's available to be sold to somebody. And as I said in my testimony, when it goes to the government, I think they are indeed going around the intent of the Fourth Amendment when they're allowed to buy that when otherwise they would be required to have a warrant.
Thank you. Professor Lamdon, similar to predictive policing, can analysis of these complicated data sets predict who is likely to get pregnant, when they are likely to get pregnant, or similarly, who is likely to seek out an abortion, whether it's based on age, demographics, income, location, or other factors?
Absolutely, yeah. Predictive analytics can be built to serve all sorts of needs, and there is so much data, there's such a wealth of data available about our internet searches, who we've been messaging, what about, our period trackers, all sorts of health apps, that it would be very easy to make that kind of a predictive analytics system.
Thank you. I thank our witnesses for their excellent testimony. Before I yield back, without objection, I will enter into the record a statement for the record by Caitlin Chin, Fellow of the Strategic Technologies Program at the Center for Strategic and International Studies. Mr. Biggs.
Thank you, Mr. Chairman. Thank you for holding this hearing today. I appreciate the witnesses being here. And I've read all your testimony, listened today, and I read the guidance for both the majority and the minority. And Mr. Chairman, I would urge you to bring the Fourth Amendment is not for sale act up for a markup in this committee as soon as possible. I think it is really imperative that we do that. It's nearly impossible for an individual to participate in American society today and not have their data collected and sold. And so I'm really concerned about this. Probably 8 years ago at a forum I was at, Walmart was talking about their capacity to obtain information, and they probably had the biggest database on consumers in the world at that time. But now, with data aggregators and data brokers, our government now has probably easily surpassed that, and also private businesses as well. Ms. Lamdon, companies are, if I understand this right, with geo-tracking, geolocation data, companies are able to basically know where individuals are based on the data collected from their cell phones. Is that right?
Yes, that's correct.
And so I was called to mind in the majority briefing in March of 2019, a Gainesville, Florida man was arrested based on the fact that this geolocation data indicated he kept passing the home of where a burglary took place. But it turns out that was his biking route, and it was his exercise app. And so, Ms. Guaitin, with access to geolocation data, a company can track an individual's movements throughout the city, not just where they are, but their movements as well. Is that fair to say?
Absolutely, and that's why it's so revealing, because it can reveal not just where someone was at any given time, but their patterns of life, their movements throughout the day and over the course of even longer periods of time. Can really reveal everything.
And this information is accurate, at least as far as geolocation goes necessarily. That phone is where where the data indicates. Is that fair to say?
Well, it's accurate enough to be extremely violative of individuals' privacy, while simultaneously leaving enough room for error that people are falsely flagged
Sure.
with this information, and that's also a real problem.
Sure, and so, I mean, obviously, you'd have to have some kind of confirming evidence, you would think, other than just
One would hope.
Yeah, one would hope. And if I understand this right, and I'm going fast because I only have 5 minutes, government, business, even individuals can actually buy this information from brokers. Is that fair, Ms. Guaitin?
There are a wide range of clients, and it includes all of the entities you mentioned.
And I just want to clarify, make sure I get it right. This data could indicate where, when, and how often a person goes to a certain location or is in proximity. Is that fair to say to the panelists?
Yes.
Thank you. So, similarly, if a group acquired geolocation data for certain locations, such as ballot drop boxes, they would be able to identify frequent visitors to those drop boxes to uncover a pattern of potentially illegal ballot harvesting. Unfortunately, too many officials have dismissed this, but if you had, and as we just clarified, if you had additional video evidence of someone being at a location, confirming the geolocation data, that would be pretty important. So one tech researcher has indicated, quote, Is geo-tracking of incredible accuracy mentioned in the film 2,000 Mules possible and being used today? Absolutely. It is attainable by anyone willing to pay the right amount of cash. Yes, and it's far more detailed than you know, close quote. That's fair to say that that's more accurate than most people even realize. And when you have separate verifying evidence that might verify that, Mr. Goodlatte, Chairman Goodlatte, that would be pretty impressive evidence, would it not, of someone being at a location doing a certain thing?
If you have probable cause to obtain the information, then certainly I have absolutely no objection to law enforcement securing the type of information we've been
I'm talking about, for instance, in the 2,000 Mules movie, where they used geo-tracking location to identify certain movements of individuals by phones, and they actually went through and found the video evidence indicating that person was sticking a bunch of ballots in a box at a certain time. That would be pretty compelling evidence, would it not?
If you have corroborating evidence, yes.
Thank you. Mr. Chairman, I have a number of articles I'd like to submit to the record. New York Times article, defense firm said U.S. spies backed its bid for Pegasus spyware maker. FBI secretly bought Israeli spyware and explored hacking U.S. phones. FBI told Israel it wanted Pegasus hacking tool for investigations. And then finally, another article by, all these are New York Times, the last one being the new spy wars, and I'd asked it to be in.
Without objection.
Thank you, and I'll yield back. Thanks, Mr. Chairman.
Gentleman yields back. Ms. Lofgren.
Thank you, Mr. Chairman. I am pleased to have been involved with the introduction of this bill with you, Mr. Chairman, and working with our Senate counterpart, Mr. Wyden. And I'm encouraged by the bipartisan support that has been expressed for this measure today. I think it is essential that we move this bill. It is essential, but also insufficient. Many people, I think, in their zeal to see the immigration laws enforced, don't realize that the Department of Homeland Security, and specifically ICE, is one of the biggest privacy offenders in the government. ICE has scanned the driver's license photos of 1/3 of Americans. ICE has access to driver's license data of 3/4 of adults in the United States. ICE tracks the movements of drivers in cities that are home to 3 in 4 American adults. And ICE could locate 3 in 4 adults through their utility records. It's a massive privacy violation. I'd like to submit for the record several articles. One, a ACLU article, new records detail DHS purchase and use of vast quantities of cell phone location data, as well as an article from The Intercept. ICE searched LexisNexis database for over 1 million times in just 7 months. And finally, from the Center on Privacy and Technology, and a publication called American Dragnet.
Without objection.
I would like to ask you, Mr. Goodlatte, on whether you think, and by the way, thank you for being here, it's good to see you, whether you think the Fourth Amendment is not for sale measure as drafted would basically address this sort of dragnet around the Fourth Amendment issue that we've been discussing here. Does it get the job done?
I think it would go a long way to addressing some of the concerns that have been expressed, and it would cover all kinds of different types of actions. We've had discussion here about Planned Parenthood clinics, people visiting those, but you also would have a similar concern about people visiting gun stores. So this is a situation where the principle of protecting people's rights under the Fourth Amendment has to come first. And we certainly support the right of state and federal law enforcement to enforce their laws, but they have to do it following the rules. I think this would help, but there are other issues. Geofencing location, for example, is not addressed by this bill. There was a recent court opinion that struck down a a geofence warrant, and that may be a good sign, but I think that's something also that the committee should look into very closely. And then you have issues that don't really address the jurisdiction of this committee, but the sale of this information to foreign governments, for example, is not
Correct.
covered in the legislation, and there should be separate legislation addressing that.
Well, maybe that's something we can talk about along with our Senate counterparts. You know, I think this is important to move forward on. However, the fact that our data is being collected is an underlying problem, and we need to do something about that in addition to moving this action. Congresswoman Eshoo and I introduced the most comprehensive federal privacy legislation in Congress called the Online Privacy Act. It would set forth the most thorough and aggressive set of privacy rights among the major proposals in Congress. Now, I wouldn't ask any of the witnesses to take sides among the various measures that are being introduced, but one of the measures that I think is pending in the our sister committee, Energy and Commerce, would allow data brokers to continue to collect Americans' data as long as the data broker is acting on behalf of the federal, state, or local government. So that would include, I think, purchase of this material. Would you agree with that, Ms. Gotine or Professor Lamdon?
I think it's very important to ensure that the federal government or state or local governments cannot buy their way around the protections in existing statutory law and the Fourth Amendment. So I think any sort of comprehensive privacy legislation would need to tackle that. But I will also say that while I very much support comprehensive data privacy legislation, and I think that is an effort that Congress should throw itself into, I also think that Congress should move ahead very quickly with the Fourth Amendment is Not for Sale Act because there's no reason to delay that. I think what Congress needs to do is to close the gaps that have opened up in existing laws that are allowing the government to evade those laws while then simultaneously taking on the larger project of expanding the universe of privacy protections.
My time has expired. I very much agree with you, and I yield back, Mr. Chairman.
Gentlelady yields back. Mr. Issa.
Thank you, Mr. Chairman. Chairman Goodlatte, good to see you. I'll concentrate some of my questions on you. From a constitutional standpoint, our founding fathers, I presume that they were protecting against the British pounding on the door and coming in looking for venison to find out whether you were a poacher without a warrant. I'm assuming that if they went down the street to the pub and asked, you know, has Clancy been in here today? It was legitimate to ask that without a warrant. Would that be a fair depiction of the status quo 240 years ago?
Yes, it would, and through most of American history, that would be the case, and probably not viewed as a problem. It's the change in technology that has evolved, particularly since ECPO was passed, and we've tried to reform it. The massive amount of information that's gathered without people even knowing that it's being gathered, and the fact that information in the past was, you know, about some of the very personal things that people have would have been in their own possession, not in the possession of a third party, stored in the cloud, if you will, that changes that. And I think necessitates both the court's evolution, which we've seen in recent cases, and the need for Congress to act.
So now let's skip forward a quarter of a millennium, or stay back there for a moment. That same example, if not law enforcement, but a friend were to knock on your door and you opened it and you let him in, he'd be entitled to notice the smell of venison and could be queried on that, right?
It would be.
And if he went down the street and said, has Clancy been in? And the bartender said, yeah, he was in and he staggered out a little while ago, that would be okay.
It would.
So really, this is not a new problem, but in fact, a problem in the making, not just for law enforcement, which I understand that we're looking at the government here today, but my question to you is, the data that we're in many cases talking about in the hands of Google through Android, of Apple, and a myriad of other original source gatherers is being provided to the guy that isn't law enforcement, but simply somebody who will buy, and whether that's a data broker or the Russian government, the Chinese government, or a myriad of other people, personal data that is the equivalent of what was safely held within your house is being made available broadly to anyone who will buy. Is that a fair statement?
It is.
So as we as a committee look at this, and I realize there are other committees with some jurisdiction, not the least of which would be Energy and Commerce, our challenge is to restore the original intent being that which is held to be yours and reasonably expected to be for privacy, must be returned to privacy, not just for law enforcement, but for all those who would seek to gather it and then purchase it.
Well, I would recommend that this committee and other committees look at all of those examples, but this committee has primary jurisdiction over the intent of the Fourth Amendment, which is to prohibit government, and by that I mean U.S., federal, state, and local government from getting access to your data without probable cause.
And now I have a question for each of our witnesses. Almost all of you, I'm sure, are familiar with the HIPAA laws. HIPAA defines this privacy of personal medical information specifically and limits both law enforcement and everyone else from sharing that data without informing and without your consent. Do each of you agree that what we really need is the equivalent of HIPAA for all information that would be on that side of maybe publicly disclosed, but not intended to be disclosed, including, but not limited to, if the doctor says, "How are you feeling today?" In the waiting room, that does not suddenly make the answer, "Well, I've got a cold," be something for dissemination. Quick answers if I could, because to me this is the essence of our question.
HIPAA has the advantage of restricting disclosure to non-government entities as well. HIPAA has some of the same drawbacks as some of the other privacy laws in that it protects only personally identifiable information, and healthcare providers are selling their data in aggregate, which can then be de-anonymized. HIPAA also only covers certain healthcare institutions and providers. It does not cover, for example, app developers that would acquire some of the same data. So there are aspects in which HIPAA works better, and especially the one you mentioned, but there are also some design flaws as well.
I guess all else, if I don't hear, they agree. And Mr. Chairman, we can do better than HIPAA, I think, in this committee. And with that, I yield back.
Gentleman yields back. Mr. Cicilline.
Thank you, Mr. Chairman, for convening this group of experts for today's hearing to discuss how the government uses personal data and how it collects it. Countless corporations collect, store, package, and sell our personal data. This has become an unavoidable feature of the 21st century. Yet I think few Americans understand what happens to their data after it's been collected, and even fewer grasp the ways law enforcement can access and use their data. We have a right to our data and a right to know how it's used and accessed, especially by large corporations and law enforcement. And with that, I have a couple of questions. And I first want to say, welcome to Chairman Goodlatte. It's great to see you. So my first question is, Professor Lamdon, I know some companies allow users to opt out of data collection or review privacy policies. Apple is always very proud of allowing iPhone users to change privacy settings for activity conducted on its platform. Do companies need to provide notice to users that their personal data is being collected by the companies that acquire it? And are users typically aware their information is being retained and then sold? And when they do provide notice, is it usually in a way that an average user would understand the consequences? And I guess what I'm really getting to is, on the whole, do you believe allowing consumers to choose what data is collected is an effective solution to protect consumer privacy against government access to personal data sets, or does more need to be done as a practical matter to protect consumers?
Right. That's a really good question, and the answer is unfortunately, no, that's not sufficient. As we all know, we all click "I agree," multiple times a day, and those agreements are all just saying that basically whatever data we hand over, it becomes theirs. They can sell it to whoever they want, and we will not know what happens with that data afterwards. So yeah, obviously, there's a real shortcoming in our current kind of end user license agreement system where you just agree to have your data taken and resold in perpetuity.
And is it fair to conclude that most Americans have no idea that they are consenting to the sale of that data to third parties?
Yeah, absolutely, absolutely. And also, in a lot of situations nowadays, companies try to make users feel more comfortable by saying, hey, we're going to anonymize your data. And, you know, we're going to strip your name out of it. Nobody's going to know it's you. Google does that a lot. And your data can be re-identified with just several other data pieces about yourself. So yeah, anonymization is also an illusion.
And a Norwegian study found that Perfect 365, My Days, and OkCupid shared user data with a large number of third parties, including IP addresses, GPS locations, age, and gender. Furthermore, a lot of this information is collected by third-party trackers deployed by the apps and the websites. And so my question is, Ms. Gooden, how does the sale of such information to enable law enforcement and the government the ability to target Muslim Americans, as an example, LGBTQ plus Americans, other religious groups, or other historically underserved communities? And have you seen examples of that kind of use?
The short answer is yes, we have seen examples. I will say that the practice of buying data and the ways in which government agencies use that data is extremely non-transparent. There has been just a remarkable lack of transparency or even acknowledgement by government agencies that they are doing this, let alone any details about how the data is being used. But we have certainly, through the efforts of investigative reporters, have found out, for example, as I said earlier, the Department of Defense was acquiring geolocation information from a popular Muslim prayer app that's used by 90 million people, 98 million people around the world, including people in the United States, as well as a Muslim prayer app. And police departments, we know, have contracted with data brokers who advertise their ability to track racial justice protesters, Black Lives Matter, events, and the like. So we have absolutely seen that, and it shouldn't be surprising, right? Because when law enforcement has to actually get a warrant, has to show probable cause of criminal activity, that makes it much harder for law enforcement officers to fall back on whether it's conscious or subconscious prejudices. When there are no such restrictions, you are going to see more targeting of marginalized communities, and that I'm sorry to say, that is certainly what we are seeing and will see more of.
Thank you. And Chairman Goodlatte, if the government can target one community, they can target any. How concerned should we be that the government or law enforcement is able to purchase such information in criminal or counterintelligence investigations with little concern for Fourth Amendment protections?
Well, I think they should be able to acquire that data as long as they're following the rules. They have some basis for showing probable cause that they should have access to the information. But right now, we have a situation where we've shown a number of examples in our testimony here today of government agencies. And by the way, we've mainly talked about the federal government, but state and local governments are very heavily involved in this as well. They're simply going around the requirement of showing a warrant by gathering massive amounts of data and then picking at that data. When they go into court, they reverse engineer the evidence to show, yes, this person did this, this, and this, and don't show that they originally targeted their suspect by looking at thousands of law-abiding citizens to find the one. And that is exactly what the Fourth Amendment was designed to address, and why the Congress needs to act here. The courts are moving in this direction as well, with the Carpenter decision, with the Riley decision, but we shouldn't wait for the years it will take for the courts to catch up with this technology.
Thank you. With that, I yield back. Yes. I yield to you, Mr. Chairman.
Thank you. A very quick question to Ms. Goitine. You mentioned, everybody's mentioned that the government tracks Muslims. They track other religious groups like Jews or Baptists?
They could track anyone they want. I mean, these
We have any
companies...
knowledge whether they do?
We don't at this point, and again, it's not, that is, absence of evidence is not evidence of absence in a situation where there is absolutely no transparency.
Thank you. Mr. Jordan.
Thank you, Mr. Chairman. On that theme, Mr. Tolman, has geo-tracking been used for political purposes? I mean, I think about 12 years ago, we know the IRS specifically targeted conservatives. We know that the FBI targeted the conservative presidential campaign. And as Mr. Goodlatte pointed out in his testimony, the FBI has conducted 3.4 million warrantless searches. Homeland Security tried to form a disinformation governance board just a few months ago. And of course, the DOJ, as we speak, is currently targeting moms and dads who show up at school board meetings. So I want to know if this kind of data, geolocation, has been used in a political manner as well.
There's no question that it has, Mr. Jordan. I think you highlight one important aspect of this, and that's who is in power focuses on who their adversaries are. And we see that DOJ does that, and they have done that. It's especially concerning when you view its use in connection with the secrecy of FISA and the other ability that they have to justify what decisions they make. I mean, I'm aware of an individual who received a knock on the door because he was in Washington, D.C. on January 6th. He did not go on the Capitol, was not there for the rally, but he was contacted by an FBI agent because he was in Washington, D.C. on that day.
Didn't even attend the rally, but just happened to be in the capital city, his capital city, that his tax dollars pay for.
That's correct.
And yet he had a knock on the door and had to answer a few questions from the FBI.
That's correct. There's no other way that they could have known that information but for the digital footprint that he left with his phone.
And would you agree, Mr. Tolman, that Mr. Nadler's bill is a good step in the right direction to begin to deal with this problem?
It absolutely is. I think it's encouraging that it's bipartisan on this particular issue because there's nothing more important right now than reining in government potential abuse.
Let me just go down the line. Maybe I'll start with our witnesses here in person. Do you have similar, because I also have concerns about facial recognition technology and how that can be used. Do you have similar concerns, Ms. Scoyton?
About facial recognition technology? Absolutely. I think that is one of the scariest technologies out there because it could wipe out any form of anonymity that we have in our society. And we have seen the way it's been abused in countries like China that use this technology to track and essentially persecute the Uyghurs, a Muslim minority in that country. We also know that it doesn't work very well for people of color and seniors and women, and so
huge percentage that where they're off, they're wrong when we're talking about African Americans and other minority groups.
And people have been falsely arrested in front of their children.
We were working in a bipartisan way with Chairwoman Maloney on trying to get some legislation last Congress, and unfortunately didn't get it done. But I hope we do. Mr. Goodlatte, I assume you shared the same concerns.
Absolutely. And again, going back to the question that Mr. Issa had, the difference between the broader scope here and the narrower scope of this legislation is those other entities, corporations, governments outside the United States, we should address those, absolutely. But they cannot pound on your door, knock it down, arrest you, prosecute you, imprison you, fine you, tax you, regulate you. Only government can do that, and that's why this legislation is unique and ought to be
it's called the Fourth
taken up.
It's called the Fourth Amendment. Yeah, exactly. Ms. Lamdon.
Yeah, I agree with everything everybody said, and I would add that that's one of the reasons why it's so important to also make sure that the large data brokers are included, like not just the facial recognition and geospatial geolocation data brokers, because one of my fears is that if we focus on facial recognition, then the facial recognition companies will just sell their data to one of the major data brokers and it'll still find its way into the government. So I think that.
No, we got to stay ahead. I mean, I remember a few years ago I was concerned about the Stingray technology. The IRS had bought this technology which allowed this device to function like a cell tower. Now that's outdated and they're way past that. So we don't know what's coming next. So yeah, we got to make sure we design it right. But this is certainly important legislation that needs to happen. With that, Mr. Chairman, I would yield back.
Gentleman yields back. Mr. Johnson of Georgia.
Thank you, Mr. Chairman. I've listened carefully to the testimony, and I would just want to point out that as we have entered the information age with so much information being available to all for a fee, why not allow the law enforcement agencies to purchase specific data for their purposes. I'm speaking along the lines of Representative Issa, who talked about law enforcement just doing not surveillance, but just doing old-fashioned shoe leather investigatory work, going around asking questions, looking at cameras in a public camera that's mounted on a pole. Those things can happen these days. What I'm interested in is understanding among law enforcement agencies, both local, state, and federal, which law enforcement agencies are the most prolific purchasers of data? Can any of the witnesses inform us of that?
Well, it's hard to tell because there's a real lack of transparency, as Elizabeth has been saying, around what these contracts entail and what entities these agencies are contracting with. But I do know, I mean, it's well known that ICE is a major, they're developing big infrastructure that focuses on predictive policing analytics and data brokering analytics. But I do think, I mean, I think if people knew how many state and local law enforcement agencies were also using these technologies, they would be shocked. Thousands
And that's what I'd like to, that's what I'd like to know.
Yeah.
Who are the agencies, and are they state, local, or federal? And can you identify those agencies?
So I know that LexisNexis alone contracts with over 1,300 local and state law enforcement agencies, and a lot of agencies.
For what kind of data?
For all,
what kind of data?
All of the data. They sell data dossiers containing.
Generally speaking,
Yeah.
what kind of data is mostly sought by law enforcement agencies?
So they purchase data dossiers that contain over 10,000 types of data from 10,000 different sources. It's billions and billions of data points that are everything from your job history, your geolocation data, your work history, your home address, all your licenses, your voting records. I mean, just everything. And more, they're also buying predictive policing technologies. So those are algorithms that kind of sift through that data and predict, they drop heat lists about who's most likely to commit a crime, where those people are, who their associates are. It's really, really invasive, and I don't think there's a kind of data that isn't included.
Let me ask you this question. What entities or individuals are the prime targets of this data collection by the agencies that are most prolific in collecting that data?
I mean,
and we don't know who that is, but
yeah.
Tell us, what kind of data are they seeking, and against whom?
It tends to disparately impact people who already have a lot of data in criminal record system, which is usually people of color, especially Black men. And then
So we're basically talking about local law enforcement agencies developing information on criminal suspects who are thought to perhaps have violated state laws.
Yeah, go ahead.
If I could just jump in on that, when you say who is being targeted, I think that one of the main problems is that no one is being targeted. It's a dragnet. So what we are seeing is agencies purchasing entire databases of information so that they can sift through that and decide, maybe they have someone of interest, or maybe they are looking to see suspicious patterns so they can decide who they want to learn more about. This is not a situation where they have probable cause that someone has committed a crime, and so they are looking for data that would support that.
Just proceeding on a reasonable suspicion, a reasonable articulable suspicion. Shouldn't law enforcement be able to deal with data on that basis?
It depends on how sensitive the data is. If The data is, for example, not geolocation. If it's some other form of third-party records, then the standard can be relevance, and then they have to show relevance to a court and get what's called a D order. So it's both the standard they have to meet is important, but also the process that they have to follow. But let me just, when you say reasonable suspicion, the ACLU's documents show that during a 3-day period in 2018, for just one piece of the southwestern United States, DHS collected 113,654 location points. The DHS did not have reasonable suspicion for each one of those, for any of them. This was dragnet collection, so that DHS could then sift through that data and decide what it wanted to do with it.
Thank you. I yield back.
Gentleman yields back. Mr. Gates.
I've heard enough, Mr. Chairman. I believe that we can have bipartisan agreement on legislation out of this committee that might be our hallmark achievement of this Congress. But I want to echo the point Mr. Issa made. It is not just the government that engages in these really terrifying data marketplaces. It's the Chinese Communist Party, Russia, big corporations. Chairman Goodlatte, does the Walt Disney Corporation engage in this terrifying data marketplace?
I don't know the answer to that.
But sure, they're lobbyists, right?
I do work for them, but I don't know the answer to your question.
So wait a second, you used to chair this committee. You come here and you tell us about all the harm in this data enterprise, but you don't know that, I mean, you're the Republican that the Disney Corporation hired because they have problems with the Republicans, and you didn't ever talk to them about this?
I came here today to testify regarding the importance of this legislation, which, as you noted, is bipartisan, and
So the LA
relates to-
Times
it relates
says
to the
Disney
importance
is
of the
running the
government.
happiest surveillance operation on earth. Had you seen that article from the LA Times?
Have not seen it.
I think it might have been when you were chairman that it came out. And Disney's actually been sued. And they've been sued because Disney installs software on applications used by children, and then they not only buy data from data brokers, Disney then turns around and sells the data that they collect off of children. Are you familiar with that litigation?
I am not.
And there's a Forbes article that came out while you were chairman of this committee, and it talks about the robots that Disney sends around its park to collect data on the people at the park to utilize. Quote, Disney is even dabbling in making robotic versions of Mickey and Minnie and all of its characters that would move around with the guests and interact with them. So as you sit here and talk to us about the harm of this data enterprise, are you concerned that the people who pay you also engage in that very same work?
I think that it would be appropriate for the Congress to look at data collection practices beyond the scope of what this committee is looking at here today. But I also think it's very important to understand that what government can do with that data is very different than what individual enterprises can do. And so that's why I'm here to talk about the Fourth Amendment.
But sometimes, right, I saw in your testimony you say, well, only the government can tax you and only the government can regulate you. But what I'm worried about is that private entities can try to program you. They could try to get you to think a certain way, and they can use this data in a very harmful way. And like particularly with the Walt Disney Corporation that is in business with the Chinese Communist Party, that thanks the Chinese Communist Party for all of the accommodations they got in the filming of Mulan. Like, you know, does it concern you that the Walt Disney Corporation is selling the information of children?
I don't know that that's the fact.
Are you being purposefully ignorant to the fact that Walt Disney engages in the very activities that you're here testifying against?
Well, I do not know the facts that you've stated, so I can't comment.
Well, right, but are you purposely not learning them so that you can simultaneously take money from Disney to try to make them look less evil to Republicans and then advocate on behalf of other organizations before the Congress that critique the very work that Disney's doing?
I'm here to advocate on behalf of people who are concerned about abuses of the Fourth Amendment.
Chairman Goodlatte, do you remember a conversation you and I had when you led this committee at the Capitol Hill Club where you said the best way to be successful in the Judiciary Committee is to find interest groups that are opposed to one another and to tell both of them that you'll support their positions so they'll both make donations to your campaigns?
I definitely do not.
You're under oath, Chairman.
Conversation. I do not.
No. Well, I hope that's not the case in lobbying as well, that you go and, that as a legislator, you try to find interest groups to play off of one another. Then as a lobbyist, you go and take money from the Walt Disney Corporation that is quite literally buying and selling data in precisely the way that you find objectionable today. I think it's a reason why a lot of people are concerned about folks who go from being in Congress to being members of the lobby corps and then using the relationships and that they've developed in order to sell influence. And that selling influence can be just as damaging sometimes as the buying and selling of data. And the Walt Disney Corporation that, that goes against so many of the values of their own patrons certainly isn't worthy of that. And, since there's no federal, legislation on this issue, it doesn't seem like it's preempted. So maybe if we had a really smart governor like Governor DeSantis in Florida, they could actually have state-based laws that would attack these issues. Wouldn't that be quite a thing? Mr. Chairman, I now seek unanimous consent to enter a few articles in the record.
Listen.
I have Disney takes over Hulu, a company with serious data collection issues, from Combardo.com. I have from the LA Times, Disneyland is tracking guests and generating big profits doing it. I have from WDinfo.com, Disney facing lawsuit over collecting and selling children's personal information. And I have Disney uses big data, IT, and machine learning to boost the customer experience, and that is from Forbes.
Without objection, and the time of the gentleman has expired, Ms. Garcia.
Thank you, Mr. Chairman, and thank you for convening this very important hearing. I apologize, I was tied up on the floor in a few matters, but I just want to say that it's refreshing to see that we have a bipartisan hearing this morning. We simply cannot allow our government to descend into a surveillance state, enough of big brother government snooping around our lives. The Fourth Amendment's protection against unreasonable search and seizure is not just a flowery phrase we learned in law school in our Constitution. The government cannot bypass constitutional limitations through private contracting. Allowing law enforcement and intelligence agencies to outsource their public function through data brokers and obtain Americans' personal information offends the rule of law. This unchecked practice is a threat to our democracy. It undermines our civil rights and our civil liberties. As history has made clear again and again, unchecked government policing weighs heavier on the already oppressed or marginalized, the poor, communities of color, LGBTQ+, individuals, and immigrants. Mr. Chairman, I ask unanimous consent to enter for the record several articles. One by Politico entitled Homeland Security Records Show Shocking Use of Phone Data. Secondly, Washington Post entitled ICE Investigators Used a Private Utility Database Covering Millions to Pursue Immigration Violations. Also, a Wall Street article, Federal Agencies Use Cell Phone Location Data for Immigration Enforcement. According to these reports, the
Without
ICE...
objection.
Thank you, Mr. Chairman. According to these reports, the ICE accessed databases containing phone, water, electricity, and other utility records. This data included 400 million names, addresses, and service records from more than 80 utility companies, including water, gas, electricity, phone, and internet, basic necessities. Professor Lamdon or Ms. Goting, both of you, can you describe the quantity of information available to ICE agents at any given time or any other law enforcement that has similar contracts?
Yeah, I compare the way these agencies get data to a fire hose. They get data from thousands and thousands of sources updated in real time. They have billions of data points, and they have these dossiers that are linked to each of our names. They have over 30 million dossiers that are just constantly getting updated with new data. And then on top of that, they have data analytics that sift and sort the data. So even if I don't know somebody's full name, or I only know part of their phone number, social security number, I can enter that tiny little bit of data about somebody that I know and pull up their entire dossier. And then I can sift and sort people based on where they are.
Do you know any specific as to utility records that are used against immigrants in terms of ICE?
Yeah, specifically. So they often say that when ICE track somebody and ICE locate somebody, the first thing people ask is like, how do they know who I was? How do they know where I live? And that is linked to the NCTUE, that utilities data, because it connects your home, your like license plate. It connects critical pieces of data about you together. And then that can be linked to all of that other data, that fire hose of data that is coming in. So it just gives ICE and other agencies just a really robust data set to kind of have a lot of different ways to see where you are at any given time, what you're doing. People have been found based on like Facebook posts that there was a woman who was selling piñatas, and ICE agents were able to track that Facebook post through these data dossiers that include that utilities data to her, and they offered to buy one of her piñatas as pretext to then, arrest her.
Well, I like piñatas, for the record. Professor, can you shed any more light on this, particularly regarding ICE? I'm sorry, I thought there was a Professor Lamdon in the group.
Oh, Professor, is it?
There's two professors.
Yeah, there's two. Sorry, there are two professors.
Oh, I'm sorry. So where's the other professor? There she is.
Professor Wexler. Yeah,
She's on
Professor
the screen.
Wexler.
I'm sorry, since I got here late, I didn't get to see everybody.
The issue that I would like to highlight for the committee is that regardless of what data is being targeted or who's being targeted, allowing the accused to challenge the quality of the data is essential to prevent wrongful arrests and accusations and convictions. Thank you.
Thank you. And Mr. Chairman, I yield back. I see I only have 1 second. Thank you.
The gentlelady yields back. Mr. Bishop.
Thank you, Mr. Chairman. Mr. Gates's questions had sort of focused my mind a bit. I was somewhat taken, Mr. Goodlatte, with the suggestion that it passed this bill, our jurisdiction is focused on the Department of Justice and so forth, how the Fourth Amendment is interpreted, and so we ought to focus on that. But isn't it possible that proceeding in that way would just empower private entities more? Can't private entities, when they gather these massive stores of data, can't they be the source of abuse?
Oh, certainly they can, and I believe that legislation should be pursued in that regard as well. But the fact of the matter is, this committee has jurisdiction over this narrower focus regarding protecting the Fourth Amendment. And the broader issue also should be addressed, but it encompasses more committees than just this one.
Ms. Goitin, is that how you say your name?
Goitin.
Goitin, thank you. Let me sort of pursue that also with you. So it concerns me that by proceeding to restrict government in the way the Fourth Amendment Not for Sale Act would do, that we would reduce political pressure to deal with the rest and might in fact empower private entities to engage in abuse. What do you have to say to that?
I wouldn't say that at all. I really don't think this is a zero-sum game here. I think we can build privacy, start with the low-hanging fruit, which is these loopholes that have opened up in existing laws because it's easy enough to get those plugged, and at the same time, you can be working on expanding the universe of privacy protections. And I don't think it would remotely take away the political pressure, because a lot of the companies that we're talking about really have become household words and villains, frankly. I think people are upset about the ways in which advertisers and other corporate entities are using their personal data without any meaningful consent on the part of those people, as Professor Lamdon was talking about. I see no reason to fear that people will simply forget about privacy issues if the government is required to adhere to the legal process that the Fourth Amendment and Congress have put in place.
How about you, Mr. Tolman?
Well, I would say that the first order of business is to make sure that there is transparency and accountability with government. If you can't do that, then when you seek to rein in the private sector, you are incapable of utilizing government to do so.
Ms. Wexler?
Well-meaning privacy statutes that try to regulate commercial exploitation of information have a disturbing trend. They often include exceptions for law enforcement access, but no exceptions for criminal defense counsel access, meaning an unintended side consequence of those privacy statutes is that they increase disparities between investigations of guilt and investigations of innocence. It would be wonderful for the committee, if it's considering those regulations, to include parallel, symmetrical exceptions or no exceptions at all. Thank you.
So, Professor Wexler, just maybe to pursue that, I sort of followed it. I never did any criminal law, but is it conceivable that you would be, by imposing the restrictions you describe on government, that you would be unilaterally empowering defense counsel or the defense against government and creating an a tilted playing field for criminal prosecution?
There is a possibility that privacy statutes could selectively prohibit law enforcement and not prohibit criminal defense access, but the majority of privacy statutes do the opposite. They selectively empower law enforcement investigations while entirely or largely blocking criminal defense access. So an example is the Stored Communications Act. Section 2702 gives a broad bar on service providers disclosing voluntarily the contents of stored communications. 2703 has an exception for law enforcement, but there's no exception for criminal defense investigations.
Professor, I appreciate it. I didn't want to cut you off. I've got one more question I want to squeeze in. Does anybody here have any information on the FBI, the current information on the FBI's purchase and use of the Pegasus software that allows access to a cell phone without any indication on the cell phone to collect information? Nobody's up to speed on that one. That one's really spooky to me. All right. And then in that case, Professor Wexler, I've sort of cut you off. Did you finish your point?
Well, one other thing I would add is that it is also entirely within the power of Congress to enact privacy statutes that create evidentiary privileges, meaning they would entirely block both law enforcement and criminal defense access and civil litigants. Thank you.
Thank you, ma'am. I'll yield back.
Gentleman yields back. Ms. Dean.
Thank you, Mr. Chairman, and I'll be quick. I have to admit, this set of testimony is extremely chilling on this hot day, so thank you for bringing all of this to light. Thank you, Mr. Chairman, of course. Maybe I'll start with you, Professor Wexler. Pre-Dobbs and now post-Dobbs. Can you give me, describe the risk and the reality of state or local or federal law enforcement or other agencies purchasing data to identify people seeking healthcare choices, seeking abortion care? Is there any tracking, for example, of women who are tracking their own menstruation? I remember a hearing in here under the previous administration where we had administrators at ICE detention centers tracking menstruation of those young women who were detained. Scary stuff. What's the reality pre-Dobbs and post-Dobbs?
Thank you for the question. This data tracking it means that people who are pregnant and seeking access to medical care are extraordinarily vulnerable to having their data sold to vigilantes, as well as provided voluntarily to law enforcement or obtained by law enforcement across state lines. And one thing this committee could spend time considering that would be time well spent is enacting an evidentiary privilege via statute. So Pierce County versus Guian is a Supreme Court opinion authored by Justice Thomas. It affirms that federal statute 23 USC 409 creates a facially absolute evidentiary privilege in both federal and state court through statutory text that says, quote, information protected under that statute, quote, shall not be subject to discovery or admitted into evidence in a federal or state court proceeding or considered for other purposes in any action. So the data tracking that we're talking about makes pregnant people who are seeking medical care extremely vulnerable post-Dobbs, and this committee could do more than enact privacy statutes that limit or regulate access. Indeed, it has the power to enact evidentiary privileges that would block federal or state law enforcement from accessing abortion-relevant data at all. That would be time well spent.
Thank you very much. All of this conversation reminds me of the Watergate era expression, follow the money. And so, Professor Lamdon, can you describe the kinds of money that government is spending? Who's profiting from this? What authorizes the government to spend millions of dollars to collect our data? I'd like to find out about the money.
That's a really good question. Yeah, millions and millions of dollars. The ICE's contract with one data broker alone, LexisNexis, is for $16.8 million. And Thomson Reuters, another data company, has over $30 million in contracts with the same agency. And I'm not sure, like, they also have contracts with Palantir and with other data analytics companies. So cumulatively, across agencies, state, local, and federal, hundreds of millions of dollars are being spent on these contracts. And the beneficiaries are these data broker companies, right? They're the data companies themselves, these data technology and data collecting companies.
Can you speak to them? Who are data brokers? Who are these aggregators?
It's this niche industry. So there are commercial data brokers that sell data that track, to make ads that track us and to advertise to us. But these government data brokers are much more insidious because, as Chairman Goodlatte said, they actually can, break down our doors and violate our rights. And the main companies that are involved in that work are, LexisNexis, Oracle, Thomson Reuters, Palantir. On state and local levels, there's another kind of layer of data companies. There's CopLink, there's Predpol. There are all these data collection companies and then analytics companies that kind of crunch that data that are received and purchased.
And Chairman Goodlatte, in the last half a minute, anything you want to add as to following the money?
No, I think Ms. Lamdon has covered it very well.
Thank you very much, and I yield back.
The gentlelady yields back. Votes have been called on the House floor. The committee will now stand in recess until immediately after the conclusion of these votes. The committee is now in recess.
The House Judiciary Committee will come to order. Mr. Buck is recognized.
I thank the chair. Chairman Goodlatte, I have a few questions for you. The first one is, do you like action movies?
I do.
I do also, and I don't have a great memory on all the movies, but I remember Bourne Ultimatum and how the U.S. government used sort of a geolocation tracker to track people without a warrant. Constitutional, unconstitutional?
I don't know that we have enough facts, but probably at least partly unconstitutional.
Okay, and there are other movies that have the government looking at bank information without a warrant. Constitutional, unconstitutional?
I would say unconstitutional.
And they actually have some movies where they are doing surveillance, but they have these super cool things that probably exist now, I've just never seen them, that you can look inside someone's home and see what they're doing inside the house, not just through an open window, but through a wall. Maybe they go down the chimney from a satellite or some crazy idea. Constitutional, unconstitutional?
I would have to defer to Liza or somebody else on that one, because I've seen some court decisions on that, and I'm just not sure how the courts came down on it. But
okay, let me ask you
I
this
would be a
then.
little suspect of it.
How about creepy?
What's that?
How about creepy? Can we use creepy instead of constitutional? It's kind of creepy to have people looking through walls at what you're doing inside your house.
Creepy for sure.
Okay, and so I guess what I'm trying to get to is government can't do those things directly, and it shouldn't be able to do those things indirectly. And Chairman Nadler has a bill to that effect, and I want to support that legislation. What I'm concerned about is, should corporations be able to do that? And particularly a corporation like Google. Should Google, you get when you sign up for a Gmail account, you get this contract, and on page 23, there are 2 sentences that say you waive everything. Should the government, or should Congress, have some requirement that each time you are making a waiver, you have to enter into that agreement? Or you have a choice. You can waive everything, you can waive it each time you use it, or you can never waive it. Should there be something out there that at least inhibits, to a certain degree, the private companies from doing that which we find creepy?
Congressman Buck, I would say that the more opportunities that the consumer has to decide for themselves whether or not they want to make certain information available to Google or other companies, and control how Google might utilize that information, the better.
And I love the fight that goes on sometimes between Apple and Facebook and some of these other companies. I love it when two giants are fighting over something. And there's occasions where Apple will assert certain privacy. I think they have a business interest, frankly, in asserting that privacy, but they will assert certain privacy on behalf of their customers. But if we had 10 Googles, if we had a DuckDuckGo that was prominent, would that help solve part of this problem? If we had competition and there was a niche market for some consumers like you and I, who just find it creepy that these companies know everything about us, because we have the audacity to want to know how to get from point A to point B, from our home to a Christmas party at some coworkers that we've never been to before, and we use a GPS device to get there. Now they know everything everywhere we've been. And we just want to use technology in a way that benefits us, and yet they have this surveillance economy where they're creating this data profile on us. Is there a benefit to competition in the marketplace that could help deal with some of these issues?
I think the more choices the consumer has in terms of how they can control their access to their information, so that if one competitor, and Apple does promote this, and DuckDuckGo does promote this, the more opportunities you have to choose. I'm going to use this search engine, I'm going to use this operating system, I'm going to use this Gmail or email account. I think the better off the consumer is.
In the last few seconds I have, how do we use the antitrust laws to try to expand competition and create that kind of opportunity for consumers?
Well, I think that antitrust laws definitely should be utilized to promote competition. Giving the consumer more choices is a benefit of more competition, and so I think that Congress should always look at it from that perspective.
Thank you very much, and I yield back.
Okay, Mr. Raskin is recognized.
Could Ms. Scanlon go before me? And we switch?
Ms. Scanlon is recognized.
Thank you so much. You know, as more of our lives shift online, obviously robust digital privacy protections become more and more important. And the immense catch of digital data that we each generate by carrying one or two smartphones or whatever, it becomes really staggering. Obviously, legally, we've got to catch up some. And it seems as though the Supreme Court's kind of narrow and antiquated, possibly, interpretation of personal privacy rights is not meeting this moment. So I had a couple questions. Ms. Goyton, is it? The Fourth Amendment guards against unreasonable searches and seizures. And it's been interpreted by the Supreme Court in Katz to include a reasonable expectation of privacy. Do you think that Americans still have a reasonable expectation of privacy in their online browsing and cellular phone use when we hold that up against the Katz decision?
They absolutely do have a reasonable expectation of privacy. Whether the court will acknowledge that they have that expectation and honor it is the question that I think we're all asking. As I mentioned in my opening remarks, the Supreme Court has begun to catch up. And the fact that the court recognized that people have a reasonable expectation of privacy in their cell phone location information, even though they, quote unquote, share that information voluntarily with the phone company, that is a major step forward, because it means that even when information is stored by a third party, highly, highly sensitive information, the court might still be willing to give it protection. Unfortunately, the court very explicitly limited its holding in that case, Carpenter versus the United States, to the facts of that case, to historical cell phone location information collected by the police. And it could be years before the court looks at, say, web browsing history or DNA or communications metadata. Each kind of information, each technique by which it's collected and stored, each kind of company that stores it and shares it is going to be a different use case, a different fact pattern that comes before the court, and it's going to take years. Americans' Fourth Amendment rights should not hang in the balance during that period. That's why it's so important for Congress to step in and fill that gap.
Yeah, it's certainly something. You've raised several issues. First of all, this idea that we voluntarily turn over this data when it's voluntary. If you want to use the service, you end up forfeiting a lot of this data. So what can we do? I mean, we're in a situation where there are any number of things we would like Congress to pick up the ball and enact legislation, if we can get our Senate colleagues to go along. What do you suggest we do?
I think there's been broad bipartisan consensus here today among the witnesses and among the members that the Fourth Amendment is not for sale act is an important measure and that it should be passed quickly. What that law will do is it will close some of the gaps that technology has opened up in the Electronic Communications Privacy Act and also the Foreign Intelligence Surveillance Act. So it will plug the gaps in existing laws that are allowing the government to evade those laws. That's something that can be done quickly and in a very straightforward way. At the same time, I think there's also been fairly broad agreement that it would behoove Congress to undertake comprehensive data privacy legislation. That's a big project, but Congress should throw itself into that effort.
Thank you. Professor Wexler, we've heard a lot of concerns raised recently with the abortion bans that are going into effect in some states about how data could be used to track women's travel or attempted access to reproductive health care. Can you talk about how that relates to our hearing today with respect to concerns about law enforcement using data and how that compares to other criminal prosecutions?
Absolutely. Thank you for the question. It's a real concern. There's been a lot of discussion about period tracking apps and other reproductive health apps, and those do put pregnant people seeking medical care at risk. But it's not only those apps. It's location information, it's web search history information, it's chat messages, text messages, unencrypted chat messages have already been used to charge a woman who was miscarried with feticide and another with murder. So the discussions the committee is having now on data privacy are all the more urgent post-Dobbs, but I would urge the committee not to stop at the Fourth Amendment is Not for Sale Act or at a privacy statute, but enact an evidentiary privilege that would block federal and law enforcement access, as well as civil litigant access. Thank you.
Thank you. And I yield back.
Mr. Chapman. Thank you very much. I want to thank the witnesses for sharing their insight today so that we can get a better understanding of the collection, use, and retention of personal data, which is obviously a very, very important issue. And I would note that Chairman Nadler and I worked together on something called the Defense of Privacy Act back in the day when I was actually chair and he was ranking member of the Constitution Subcommittee, and something that we worked on pretty earnestly for quite some time. And back then, our primary concern was the potentially unconstitutional collection of personally identifiable information by government agencies. Today, most people voluntarily surrender far more information to private companies than the federal government at that time ever thought about collecting. And that's what makes the situation that we're discussing today so concerning to so many Americans. The breadth and depth of information about nearly every American held by private companies is breathtaking and can easily be abused if adequate safeguards are not in place. But domestic abuse of this information is not our only concern. We face significant challenges from abroad as well. In addition to serving on this distinguished committee, I also serve as ranking member of the House Foreign Affairs Asia and Pacific Subcommittee. And on that committee, we strive to counter the immense threat the People's Republic of China poses, not only to Americans, but to the human rights of its own people. It's well known that the Chinese Communist Party uses a vast surveillance network to track, analyze, and manipulate its 1.4 billion citizens. The CCP, the Chinese Communist Party, sees information as power. Their dream is a database that fully integrates everyone's movements, phone records, spending history, interactions with friends, health records, social media posts, and on into one giant web of surveillance. We're not China. The Fourth Amendment protects against warrantless searches and seizures. The Supreme Court has long interpreted the Fourth Amendment to safeguard the privacy and security of individuals against arbitrary invasions by government officials. Given the constant evolution of technology, virtually everything about an individual nowadays is online, whether you intentionally put it there or not. Accordingly, Congress must continue to exercise oversight to ensure the reasonable expectation to privacy that's guaranteed under the Fourth Amendment. That we have to make sure it's not compromised by law enforcement, by purchasing bulk data information without a warrant, or by foreign actors who would steal the same information for their own nefarious purposes. So now I'll get around to a question. Chairman Goodlight, let me ask you this. How should policymakers balance the competing interests of the government's ability to prevent crime and the civil liberty interest to the American citizen? And I preface my question by noting that I know versions of that have probably been asked. I was actually in the Foreign Affairs Committee up to this point, and so I apologize if you've already been asked that.
I don't think you've been framed quite that way, and that's a very good question. It's obviously very important for law enforcement to have the tools they need to prevent crime, to solve crimes that have already been committed, and to effectively prosecute the individuals who perpetrate those crimes. But I would argue that just in the last maybe 2 decades, it has gotten out of balance because the nature in which people store their data has changed so dramatically. Information that you didn't have stored, didn't have in writing anywhere at all in the past, now is stored about every aspect of your life, and it's stored by a third party. So the old adage that if you don't hold it yourself, you're not subject to a warrant. If a third party holds it, they can get it without a warrant, has got to be reviewed. The Supreme Court has recognized that in the Carpenter decision, in the Riley decision, with regard to cell phones, with regard to geolocation information. And so I think it's important that the Congress recognize that if we wait for the courts to step up and not address the underlying doctrine itself and say that given the amount of information that is stored today, that a new standard has to be set, and that's what this bill attempts to do in terms of the information that can be garnered by law enforcement without having to get a warrant, without having to show probable cause that they need it. And so I think you can achieve that balance. I think law enforcement can be effective, but I think they do need to operate under new rules given the unbelievable amount of information that they can simply walk around the Fourth Amendment and buy now instead of having to comply with traditional doctrine.
Thank you very much. My time's expired, actually, I think. Yeah, thank you. Mr. Raskin's recognized.
Thank you, Madam Chair. Seems to me that most people believe as an abstract proposition that people have a privacy right, if not a property right, in their own digital communications, their own digital history. Although I don't know we've established that anywhere, and that might be something we really need to talk about. The problem is that when you get to a specific criminal investigation or civil investigation and people know that there's a record out there relating to it, I think if you polled people at that point, people would say, well, if there's a record, then the record should be made available. And so I guess I'm asking, what do we do about that basic problem? It seems like technology has a kind of momentum of its own, and once the facts and the data exist, there's a sense that, well, the government should have access to it. So Professor Wexler, let me ask you about that.
Thank you for the question. Evidentiary privileges exist. The attorney-client privilege, the spousal communications, the priest-penitent privilege, and there are also a slew of statutory evidentiary privileges that Congress has enacted. Those shield existing data from law enforcement and civil litigants. They block warrants, they block subpoenas, they block discovery orders, they protect against wiretapping. If law enforcement accidentally oversees a privileged communication, they have to use a taint team to purge that content before delivering it to a prosecution team. So privileges are more powerful than torts, than contracts, than fiduciary duties, and they are even more powerful than the Fourth Amendment. They exist for good reason, and they could exist for abortion-relevant data. Thank you.
So what is the privacy privilege you're positing there, or you're arguing for?
Any abortion-relevant data could be covered. Now, this is the specifics of this would be something that the committee would have to look into. I'd be happy to help however I can, but it's certainly within the power of this committee to identify especially sensitive data and protect it with a statutory evidentiary privilege.
Okay, so Professor Wexler seems to be positing a specific policy cutout for an evidentiary privilege related to abortion-related travel or speech or so on. But we're also talking about the more general problem, right? And Professor Goitein, let me come to you. The legislation I understand we're talking about is to prevent the government from purchasing information from data companies that it cannot otherwise obtain directly. Is that right?
That is right, and it would not prevent the government from obtaining that record if it could meet the legal standard that would otherwise apply. So if the government can either get a subpoena or a court order or a warrant under the applicable legal standard, it will have access to that record. And that gets to both your hypothetical about people wanting their data to be private, but also if there's a record in existence, wanting the police to have access if it will help with solving criminal activity.
At least access through some kind of legal mechanism. Yeah.
That also gets to Congressman Chabot's question. This is all about the balance between privacy and law enforcement, the legitimate needs of law enforcement. And that balance was established by the framers in the Fourth Amendment. So Americans have privacy rights. Those rights can be overcome if the government can show probable cause to a neutral magistrate.
So this is essentially the meta-technological equivalent of saying that if the government can't enter your home without a search warrant, they can't pay somebody who goes into your home, who breaks into your home, or otherwise gains access through some kind of duplicity, saying that they're a carpenter or a plumber or whatever, right?
That's an excellent analogy.
Mm-hmm. How big a problem is this? In other words, has it become a habit of government to be able to purchase data from companies in order to essentially execute warrants or obtain evidence they would not otherwise be able to get?
It certainly seems that way. And I will say again, I can't stress enough that the government has been completely non-transparent about this practice. And so what we know from investigative reporting, from non-governmental organizations that have done their own investigations, from lawmakers who have asked probing questions, and from that, we get pieces of a puzzle, and those pieces, I think, leave no doubt that this is a widespread practice now among many federal agencies and state and local agencies as well.
Well, I thank you for that, Madam Chair. This sounds like very sensible legislation to me, and I'll yield back to you.
Thank you. And Mr. McClintock is recognized.
Thank you. Mr. Goodlatte, there seem to me to be two principles here. One is I feel very strongly about the Fourth Amendment's protections, and it seems to me to be crystal clear. We have a right to be secure in our papers, those things that we either write down or say privately. And in my view, that would include metadata about those records. And I'd even go a step farther and say whether your papers or effects are stored at your home or are entrusted to some third party for storage, they're still private, and they would require a warrant to search them under the Fourth. However, a person can waive these rights in a contractual agreement with another party if they wish to. If a person agrees to terms of service that allow disclosure of aspects of their private papers, it seems to me they have that freedom. If they don't like the privacy provisions that a company offers, they don't have to agree to it. They can choose a competitor or do without. I mean, I'm old enough to remember when we did without all of this digital technology. I don't for the life of me remember how we did without it, but we seem to do so very nicely. So my point is, why should we interfere with the right of two parties to agree to terms of service? What's wrong with that?
Well, that's a separate issue from the core issue in the Fourth Amendment's Not for Sale Act. I do think that it would be good for the Congress to look at that underlying issue that you refer to, considering the fact that I'm not the most prolific user of the internet, but I counted yesterday on my phone, I have 160 apps. Most of those apps are gathering information about me and storing it. I don't...
Yeah, well, and by the way, I would assume a lot of those apps sell that information. That's how they make the money to pay for the app and to provide you with that service.
Correct.
So if they can't sell that information,
correct, but
wouldn't they have to charge me for the service they're now providing me for free? And how does that help me as a consumer?
Well, first of all, I think that the important thing there is that the consumer understands and has that choice.
Right.
That's a different issue than
that's
what's
what
before us
means
today.
to be a grown-up. You have to read it and stand by your agreements.
Right. The Fourth Amendment does not apply to that transaction. The Fourth Amendment applies when the government wants to buy.
I have waived my right under the terms of privacy that I've agreed to in exchange for the service they're providing me.
Correct. But did you waive your Fourth Amendment right to not have the government, which would otherwise be required to have a warrant or a subpoena or some other court order to get that information.
Well,
just because you had a transaction with a company that got your information.
I've told the other party in that contract it's okay for you to sell certain information. You're bound by the terms of that contract. You can't sell information beyond that. But I've agreed to allow you to do that in exchange for the service that you're providing me.
I think that would.
Why would we interfere with that?
I think you're interfering with it because the government has powers that other entities that might buy that information do not have.
Which is why we have a constitution to restrain it. But that constitution guarantees me not only my Fourth Amendment privileges against the government to come snooping into my affairs, but it also gives me the freedom to enter into contracts with others for that we find mutually beneficial. And I may find it mutually beneficial to get this free service in exchange for selling certain of that data. That's an informed consent that I have a right to.
Right, but the sale of the information to the government puts the government in the picture as well, and the Fourth Amendment is directed at the government, not obtaining information without showing probable cause, without providing a warrant.
Let me ask you one other question on location data. It doesn't seem to me that falls within the papers and effects definition. If someone observes your movements in public, that isn't a search or seizure. I observe you right here before me. Whether I make that observation once or 100 times a day doesn't really matter. How does location data fall within the Fourth Amendment?
Well, I'd have to go back to look at the Carpenter decision to interpret exactly how the court did that, but the court has held that, and courts have held that under certain circumstances that information is protected.
Thanks.
Will the gentleman yield for a question or a point? Because I think you make a good point that maybe it's not unconstitutional, maybe it doesn't violate the Fourth Amendment for the government to go to one of the big companies and say, we're going to purchase this data. But the question for us is the policy question. As citizens, do we want our government engaged in the business of purchasing?
I understand that, but the flip side of that is, do we want our government interfering with our right to contract with providers for services that we may find appealing under the terms of that agreement? If they're providing, again, the alternative is, if they're making money right now selling this data that I've told them they can sell, if they're not allowed to do that anymore because we've stepped in, they're going to have to charge me.
Well, they can still
charge me
do
as a
it.
consumer for that service, and I'm not sure that's in my interest as a consumer.
They can still sell it to the rest of the world, but what we're saying is, as citizens, we don't want our government circumventing Fourth Amendment restrictions by being in that market.
Yeah.
Yeah.
Gentlemen, your time has expired. Mr. Swalwell is recognized.
Thank you. I want to focus on what access to locational data and personal data means with respect to living in a post-Dobbs world where a woman's right to reproductive freedom is now being infringed upon, and we're seeing state efforts to try and track down patients who are crossing state lines to seek abortion services. The Attorney General of Indiana is investigating a doctor who performed a termination of pregnancy on a 10-year-old who had to leave Ohio after she was raped to go seek this service in Indiana. And so I have a lot of concerns about what this could mean in the future. And I want to begin with the Republicans in the minority have promised that if they were to achieve the majority, if they were to win the House in November, that they are going to use broad subpoena powers in their new majority. And so my first question is for Professor Wexler. Professor Wexler, if Jim Jordan, as chairman of the Judiciary Committee, wanted to seek a patient's records or a patient's travels under locational data that's available, would he be able to do this with the amount of data that is out there?
Absolutely. The existing data would be vulnerable to such a subpoena. There's a wealth of data to track pregnant people's actions seeking medical care. However, if this committee enacted an evidentiary privilege, that would also have the power to block a congressional subpoena.
And if Chairman Jordan and a Republican majority wanted to go after doctors who perform abortion services or doctors who are in communication
with patients, is there enough data out there that under the law today he would be able to do that?
Yes, there is.
And if Chairman Jordan, in a Republican majority, wanted to go after abortion service providers to understand who they're communicating with, would he be able to subpoena this type of data?
Yes, he would, and existing privacy statutes like HIPAA would not prevent that, even though they apply to traditional medical service providers because they have exceptions for law enforcement access, and that would apply for Congress. I'm almost certain I could double check that and provide confirmation for the record.
And in a Republican majority, would Chairman Jordan be able to subpoena companies who provide travel reimbursements or travel to employees who have to leave their state to go to a state that can provide abortion services?
Yes.
Crisis pregnancy centers, which continue to skyrocket as states across the country ban abortion, are faith-based groups that often misrepresent themselves as reproductive health clinics. Their mission is to dissuade pregnant women from having abortions at any cost. A recent Time magazine investigation shined a light on how far these centers will go to harm women who are seeking essential health services. In fact, the Times study found that these centers collect substantial sensitive data on women who come to them for help, including addresses, marital status, demographic information, sexual and reproductive histories, test results, ultrasound photos, and information shared during consultations. But because crisis pregnancy centers are not licensed medical clinics and offer their services for free, they are not legally bound by federal health data privacy laws. Furthermore, these clinics often do not employ privacy notices which prohibit data obtained from being sold to the highest bidder. Professor Wexler, can you explain how crisis pregnancy centers would be able to weaponize data against women who are merely seeking additional resources when they aren't able to obtain an abortion in their state?
Well, any private entity who obtains data that would identify people who are seeking abortions could voluntarily hand that information to law enforcement, who could use it for anti-abortion prosecutions, or under some state statutes, they could sue as civil plaintiffs as well.
So you're telling me that a woman who is making the very personal decision about whether or not she wants to have a pregnancy and have a baby could go to a pregnancy center, consult with the employees at the pregnancy center, and that they would be able to obtain data under the laws that exist today and turn it over perhaps as a bounty, as you would be able to do in Texas if they believe that she was going to have an abortion.
That's correct.
I yield back.
Mr. Tiffany is recognized.
Thank you, Madam Chair. I'm assuming the gentleman from California wasn't referring to the bounties that have been put on Supreme Court justices.
Would the gentleman yield?
We heard the conjecture that was going on.
Would the gentleman yield?
No, I will not.
Well, you asked me a question.
No, not a chance.
And I wasn't referring to that, and I condemn all violence. Why don't you do the same?
Time back.
You do the same.
May I have my time
You
back?
condemn violence, I'll do it too.
May I have my time back? The gentleman that was referred to in the previous question, Representative Jordan, he actually spoke favorably earlier in this committee. I think we all heard that. He spoke favorably towards this bill, and to do all this conjecture is just to scare people, and it's really unfortunate. Ms. Goitin, you heard the exchange with Representative McClintock earlier, and would you like to comment on what you heard there, and are there protections in place that should be?
Sure. The notion that when a person accepts the terms and conditions of an app, that this is a sort of equal negotiation between parties in which voluntary choices are made and everybody leaves with what they wanted out of the transaction, belies the reality of these situations where, first of all, the consent is not truly informed consent. If you look at these privacy policies, these terms and conditions, apps will often say that they will not disclose your data to the government and that they will not disclose your personal data at all. But they will not tell you that they are going to disclose your data in aggregate or in an anonymized fashion to other entities that may very well disclose it to the government. I have yet to see a privacy policy that actually says, we are going to give your data to third parties, and those third parties can do whatever they want with it, and even though we've de-anonymized it, you can be identified, it can be traced back to you. I haven't seen that policy, and I don't know how many people would readily consent to it. That brings me to the second point, which is whether there's actually truly a choice here to consent, because this is the business model, certainly for free apps. If you are not paying for the product, you are the product. And if you decide that you don't want any of these companies to share your data, you are effectively saying that you're not going to use apps, which is another way of saying you're not going to participate in the conveniences of modern society. The Supreme Court in Carpenter was very clear that the Fourth Amendment does not require people to choose between their Fourth Amendment rights and participating in modern society. So I think the analogy just doesn't hold up.
So are you somewhat saying that there's different forms that they deliver this message or these messages or your information to the government? Is that accurate?
That's certainly accurate, yes.
Okay. Earlier, we had some allusion to ICE, and Ms. Lamdon, I'd like to address a question to you. We were talking about limitations of using data and what this bill is all about. When it comes to protecting our border, including we've had the greatest number of known terrorists that have crossed our border, should all these limitations that we're talking about here today, should they all be in place for people that want to come illegally into our country?
Everybody whose data is being used by law enforcement should have transparency and notice around that. I think that just applies to kind of all humans who make these, as Liza pointed out, not really kind of illusory agreements, right? We're all agreeing, we're all volunteering to give our data over, but it's in order to move about with our phones or, you know, just do the basic things of life. And I think that there's a balance between not letting law enforcement use the data at all, which is not what we're advocating for, but between giving people notice and transparency that, hey, your data will be used in this way.
So the Biden administration is giving out phones that are probably tracking people coming into the country illegally, or organizations like the Organization for Immigration, international organization. Should they be able to use that data with those tracker phones that are coming in?
Law enforcement should be able to do the work of law enforcement as long as warrant requirements and due process is given. So as long as there's notice.
If I want to get one more
and
question.
probable cause.
Thank you very much. Representative Sensenbrenner was the chairman of this committee. Mr. Goodlatte, you served with him. He wrote an article 6 months ago. It was not, the Patriot Act was not meant to be used to go after parents. Where did the Patriot Act go off track?
Well, I think the Patriot Act went off track in not defining some of the areas that set parameters around government gathering data. And so that's why we have the USA Freedom Act that followed on. It was intended to cover the government's acquisition of mass data from telecommunications companies, but it was also intended to be a broader ban on government gathering mass data. Now, I think that that should cover some of the problems that we're experiencing today, but lawyers for the government have gone right around that and said, well, as long as we're buying it, we don't have to comply with the law or the Fourth Amendment.
I wish I could pose a lot more questions, but I'll yield back.
Okay. Ms. Jackson-Lee, you are recognized.
I thank the chair very much. I thank the witnesses. I thank Chairman Nadler, ranking member, for holding this hearing. We at Judiciary Committee are being doubly tasked in our responsibility, so I'm grateful to have this opportunity. And it's good to see Chairman Goodlatte. We worked together on a number of these initiatives, including the Patriot Act, where the Judiciary Committee had to save America from violations that would have undermined their right to privacy and their rights under the Fourth Amendment without jeopardizing our national security.
But let me pose this example. In 2018, Mississippi mother Latice Fisher was charged with second-degree murder and held for several weeks on a $100,000 bond after experiencing a stillbirth. Evidence used in her indictment included online search history taken from her cell phone and showed search terms related to inducing miscarriage and medication abortion. And then in 2019, prosecutors in Ohio used a teen's online search on how to get rid of a baby as evidence that she killed her newborn in a murder case where the teen was ultimately acquitted. We want justice. We want justice in a fair way. Ms. Wexler, can you speak to how broad the use of data and invasion of privacy can get in the name of law enforcement and law enforcement's responsibility and the responsibilities that criminal courts would think that they would have?
Absolutely. So data can be abused at all stages of the pipeline. And it is essential to have some privacy regulations that restrict law enforcement access. But even restricted access, even probable cause warrants, will not protect pregnant people seeking medical care from anti-abortion prosecutions. To do that, this committee would need to enact an evidentiary privilege, which would be stronger than existing privacy or confidentiality statutes. It would be stronger even than the Fourth Amendment. It would preclude the use of abortion-relevant data in investigations or in trials.
I think if I can pursue this with you, I don't know if we would have ever imagined ourselves to be in this predicament. One, Roe v. Wade being obliterated by the court, 50 years of precedent, and then in a new world of technology where data is everywhere. Would you comment on the data brokerage firms and how they gather this information and the sense that it can be every aspect of your life?
So this is a really important question. Thank you for the question. I actually think that the other witnesses may be better able to speak as fact witnesses to the data brokerage firms. So I want to yield my, if possible, to another witness to answer that question.
Lamdon?
Yeah, I'm happy to answer that question. Data, so you're absolutely correct that these data brokering firms get data from thousands of sources and they don't reveal, there's no transparency around what these sources are. So they could easily have all of the data that you're concerned about, and then they engage in licensing contracts with state, local, federal, law enforcement, and other agencies. And the agencies can use that data however they'd like. There's no oversight or supervision about how the agencies are using these products, these data products.
Chairman Goodlatte, if I have a moment, what should Congress be doing? This is so vast. It is so, how should I say, it continues to metamorph into new technology. What should Congress be doing?
Well, I think a great first step would be to pass the Fourth Amendment's Not for Sale Act that's been introduced by Chairman Nadler, and we've heard from members on both sides of the aisle today who've given it good reviews. So there may be some additional work there. I know some members have some amendments they'd like to offer, but perhaps the committee could work in a bipartisan way to finalize that legislation and pass it out of the committee, and then there'd be a lot of people on the outside. Certainly my organization, the Project for Privacy and Surveillance Accountability, would be very committed to working to get that legislation passed through the Congress.
Thank you so very much, Madam Chair. Thank you to the witnesses. I yield back.
Thank you. Mr. Benz, you're next.
Thank you, Mr. Chair. Director Goiten, it's been suggested by a number of different people and commentators and others that if appropriate data had been gathered and appropriate algorithms applied, the tragic situation in Uvalde could have been avoided.
Sorry, which tragic?
The tragic situation in Uvalde, Texas,
Uvalde.
could have been avoided. So how would you respond to someone who suggests that data be used in this fashion?
It's always easy to say that in retrospect. It's always easy to say, oh, if we went back and looked at that person's social media posts, we would have known. The reality is that the number of people who post on social media, the kinds of things that some of the people who do engage in violent acts post is astronomically larger than the number of people who actually take violent action. It is notoriously difficult to predict who is going to engage in violence. And so while it's tempting to say, if we could go back and get access to this person's social media feed or to their data, we would find the silver bullet that would tell us that this person was going to do what they did. That's very, very tempting. It's not the reality.
Thank you. Thank
Yes.
you. Chair Goodlatte, first of all, thank you for coming to my office and sharing with me your thoughts regarding some of the challenges we face on this committee. I deeply appreciate the time you took. So at what point does the gathering of data by private companies become violative of civil law? In other words, it's often occurred to me, if everyone knew exactly how our data was manipulated, molded, folded, and utilized, we wouldn't be happy about it. And I've often thought back to law school days and thought about civil claims such as fraud and the inducement and that thing. So are there any grounds, do you think, for a private party to become a plaintiff in a civil lawsuit based upon inappropriate use, gathering, and then directing of a data?
It's a really interesting question. I think that without more of a legal structure to put constraints on the gathering of the information, unless they gathered it through some kind of subterfuge, they actually broke into a computer system and stole the information, they may not face the kind of liability that you and I might think there might be some grounds for. But I really think that this technology has gotten so far out ahead of society in general and the Congress in particular that it's time for the Congress to look at this broader issue, not just the issue that's before the committee today with regard to government buying the data, but the broader issue and what kind of liabilities should arise from that. But I think that's about all I could offer at this point.
Thank you. And a second question back to Director Goyton, and it has to do with the sweeping up of massive amounts of data, and then the assertion that's been made by several of you over the last couple of hours has been that all will be well if we simply go get a warrant for probable cause. And yet, the grounds upon which that warrant would issue are dramatically different than what they were back when I used to do very badly criminal law defense work. So how can anybody say the old standard of probable cause makes any sense whatsoever when the data in front of them is so massive and so different, shall we say, than that which we used to present when anticipating a criminal action?
Well, first I would say that a number of the different categories of data that we're talking about actually would not require a warrant. They might require a subpoena, or they might require what's called a D order under the Electronic Communications Privacy Act. So it's not all Fourth Amendment protected information that requires a warrant. It's geolocation information is one of the main commodities that's being purchased. That should be protected by a warrant. In terms of how the warrant requirement has evolved, I think that's probably a better question for Professor Wexler. I'm sorry to say I don't know enough about that.
Let's hop to her very quickly. Professor Wexler, what do you think?
Thank you. Well, one thing that's changed is that when law enforcement collects bulk data, it doesn't necessarily know flaws in the collection method. So hacking was brought up. If hacking was engaged in by a private entity, and then that information was laundered through a series of data brokers, even if law enforcement obtained a warrant at the end to purchase it downstream, they might not get access to that extremely important exculpatory information that the defense would need to know. And so one thing the committee might consider is adding additional requirements in these contexts beyond probable cause to identify and gain possession of exculpatory or impeachment material that law enforcement otherwise wouldn't obtain, and that's essential to protect defendants' Brady and statutory discovery rights.
Thank you. Mr. Chair, yield back.
Thank you very much. Ms. Jayapal is next.
Thank you, Mr. Chairman, and it's good to see you, Chairman Goodlatte. I wanted to focus my comments on another part of sensitive data, which is face recognition technology. This is also an area where we've had a lot of bipartisan interest. There's a lot of sensitive
personal information that is requested constantly from law enforcement, from both commercial brokers and state governments to surveil the public with face recognition technology. But face recognition technology is up to 100 times more likely to misidentify people of color, and there are very few guardrails in place to regulate the use. The unregulated application of this technology to our most sensitive information, our faces, is precisely why I introduced the Facial Recognition and Biometric Technology Moratorium Act, which presses a pause. It doesn't say never, but it presses a pause on unregulated government use of face recognition and biometric monitoring. This past year, the IRS planned to contract with ID.me, requiring anyone accessing their tax records online to upload images of their photo IDs and a live video of their face with a computer or a smartphone. And while the IRS ultimately abandoned this plan, ID.me still has contracts with 10 federal agencies and 30 states. And in fact, there's an entire market of commercial platforms that collect sensitive data from users to sell to the government. And because I want anybody who's watching this hearing to understand what pieces of data, I'm gonna direct some questions at you, Professor Lamdon, just on, you can just answer yes or no in terms of whether this information is available to the government. So the LexisNexis Digital Identity Network collects and processes people's online logins, payments, and new account applications. Is that information available to the government?
Yes.
Babel Street collects digital device location data derived from online advertisers and popular mobile apps. Is that information available to the government?
Yes.
Clearview AI uses facial recognition technology to harvest and store millions of photos from social media users across multiple platforms. Is that information available to the government?
Yes.
So these are just examples of the many ways in which, if you're just using the internet, you're using programs, your information is accessible. Now, the federal government also uses face recognition technology to analyze state-level data. And since 2015, U.S. Immigration and Customs Enforcement has performed face recognition scans of driver's license databases in at least 14 states. Up until the discovery of this practice in 2018, this included my home state of Washington. Professor Wexler, are immigrants the only people whose licenses are being processed here, or does it go way beyond that? What Fourth Amendment, let me just add to that, what Fourth Amendment implications does this have for every person in the country?
It goes way beyond this. Everybody's information is being collected and their faces are being included in DMV and other databases. So this is an issue that affects all of us.
And driver's licenses, when you think about it, we use it for everything. I mean, literally everything. So, Professor Lamdon, just staying with ICE for a minute, how does ICE's use of facial recognition technology on state driver's licenses impact people's lives? And are there impacts on public safety or health?
Yes. So that's why I think the title of today's hearing is Dragnet, right? They don't just pick out particular driver's licenses. They sift all of our driver's licenses and all of our data through these systems, these predictive policing systems, predictive analytics systems. And especially in the case of driver's licenses, car tracking, there have been, fatal car chases. There have been all sorts of incidents where people's lives have been put at risk due to kind of this data tracking and people's use of data. Or, I'm sorry, ICE's use of data.
So it's really not that ICE is just focusing on immigrants as they go through. They're going to take the entire scope of driver's licenses that are there and analyze anybody's, yours, mine, anybody's.
Exactly. They're going to sift everybody's data through their system, and they have access to everybody's data. And as you said, these systems tend to discriminate and have biases and have just kind of errors in them that tend to target certain types of, like you said about facial recognition, it tends to disproportionately misidentify people of color. So yeah.
Thank you. I think it's important for people to understand, and I'm glad for this hearing because the federal government has built out a very invasive and unregulated surveillance infrastructure through the use of these technologies, including face recognition technology. I had a question for you, Chairman Goodlatte, but I am out of time, so I thank you again for being here. Thank you. Mr. Owens?
Thank you, Mr. Chairman, Ranking Member, and witness for holding this very important hearing today. First of all, let me just start off by saying I applaud this bipartisan approach that this committee is taking in terms of access to our personal data, and I look forward to supporting this legislation. I also want to thank my friend Brad Tolman for his participation as a witness. Mr. Tolman has a long and distinguished career and service in my state of Utah, where he's U.S. Attorney. He's since been an innovative and fair voice in criminal justice reform, among other important issues. Ms. Tolman, Ranking Member Jordan earlier discussed a little bit about tracking of citizens for political reasons. I want to leave the remainder of my time with any thoughts you might have on that or anything else that you might want to add to this conversation.
Well, thank you, Representative Owens. It's great to see you again and to be among such discussions of such an important topic. I would say that, you know, the recognition that it goes both ways, that power can be abused no matter the political affiliation is very important. We've heard a lot of discussion about what could be done for those that, you know, may be seeking an abortion in some of the states, but it is equally as frightening to hear about the potential use based on someone's vaccination status, for example, whether they believe in natural immunity. A lot of the medical and health issues that we have discussed and seen over the last 2 years with COVID have really brought to the forefront the ability of the government to justify its use, depending on the circumstances that it's currently enduring. And I believe that can go back and forth depending on the political power that it is currently in Washington, D.C., or in our state capitals, or across even our local and state jurisdictions. We have seen that when the Department of Justice identifies a cross-section of individuals it's concerned at, you hear language frequently suggesting that they are a domestic threat, for example, or they may pose a domestic threat. This is language that allows them to broaden their capabilities and use surveillance to that end. It should be frightening, and I'm encouraged that the Congress is taking these issues up.
Thank you so much again for your service. I yield back.
Thank you. Now more than ever, the private details of Americans' lives are for sale. And as a consequence of our connectivity, technology companies, smartphone apps, and data brokers scoop up our sensitive data, ranging from our internet searches to our home addresses to our cell phone locations, and neatly package them to sell in the marketplace to other citizens, to foreign actors, and to the United States government. While brokers claim the data they sell is anonymous, these companies maintain databases so large and aggregate so much personal information that we all may be re-identified by savvy purchasers of that data. What's more is that data collection has been utilized by law enforcement to modernize investigative tactics, relying on warrants obtained through geofencing, keyword searches, and cell site location information. While these tactics have aided law enforcement in many cases, abuse of these warrants and authorities have led to numerous civil rights violations, particularly of the Fourth Amendment's protections. For instance, in my home state of Arizona, a man was wrongfully arrested, interrogated, and imprisoned and accused of murder, all because his Google location data indicated that he had been in the vicinity of a shooting. As the New York Times put it, such location data, quote, can help solve crimes, but it can also snare innocent people, unquote, as it did in this particular case. It is not just law enforcement's ability to access this data that causes me alarm. In our post-Roe world, in the wake of several states proposing or enacting bounty-style laws which reward vigilantes for reporting their neighbors and community members to police, I have grown increasingly concerned about the safety of those seeking medical care or even just medical information about their reproductive health. In fact, I join many of my House colleagues in calling on the FTC to use its full authority to ensure that data brokers are protecting users' privacy and to strongly enforce privacy standards against data brokers who break the best practices, including by prosecuting their illegal actions. It is clear that this issue is not going away, and Congress must take action to legislate on privacy. Professor Wexler, in the Arizona case I described, a man was publicly and falsely accused of murder based upon his Google location data. How do geofence warrants create situations for misidentification and wrongful arrest?
So it's a really important question. I'm actually not an expert on the Fourth Amendment. My research focuses on criminal defendants' access to data. And so I think another witness maybe would be better to speak on geofence location warrants.
Thank you. Any other witness would like to speak on the issue of geofencing? Please.
I'd be happy to speak. Geofence warrants are when the government goes to Google with a warrant and requests the information for all of the cell phones within a particular geographic location for a particular time period. And this is something the government can then look for suspicious patterns of movement and use that to try to figure out who committed whatever crime they're investigating. And Google received more than 11,000 of these warrants in 2020 alone. Even though the government has a warrant, there's a major Fourth Amendment problem with these warrants. The Fourth Amendment has something called a particularity requirement, which roughly means the government has to show probable cause that searching a particular place, a particular home, or a particular device will yield evidence of a crime. And usually the way that works is the government has a suspect. They can show probable cause that they committed the crime, and they therefore have a justification for searching that person's home or device or what have you. Geolocation warrants work in reverse. So they allow the government to obtain the Fourth Amendment protected information of dozens, hundreds, maybe even thousands of people, even before the government has a suspect. It's the equivalent of searching every home in the neighborhood of a crime to figure out who committed it. And as you can imagine, if you're just looking for suspicious movements and then deciding that that means that somebody is your suspect, that is going to result in a fair number of false flags.
Let me ask a follow-up question. Could a geofence warrant be used in the case of an abortion provider, for instance, to identify employees or patients of that medical facility? And if so, what harms could occur because of that identification?
Yes, I mean, a geofence warrant can be used for any purpose. I mean, there does have to be, a crime that the government is investigating because there is a warrant involved. But at that point, the government can pull in the information of everyone who was at or near a healthcare provider that provides abortion care services, and that will, of course, probably sweep in a lot of people who were shopping at the convenience store next door or who were at the provider for reasons other than abortion care, as well as obtaining Fourth Amendment protected information of women who are seeking abortion care without meeting the legal standard that needs to be met under the Fourth Amendment and under the laws Congress has passed to obtain that information.
A scary proposition. Thank you. I yield my time back, and next I'll recognize Mr. Fitzgerald.
Thank you, Mr. Chair. Chairman Goodlatte, thank you for being here today. It's good to see you. FISA exists to enable the government, obviously, to conduct counterintelligence and counterterrorism operations. When other criminal activity is incidentally discovered, it can be noted and passed on to the appropriate authorities, obviously. But I don't think FISA was meant to be kind of this treasure trove of information that law enforcement has kind of discovered is very readily available and kind of at their fingertips until it was continued to be relayed to them on a regular basis, that all they had to do is, come up with the request. It's such a massive database, and there's so many other communications, some of them foreign related and international. The problem, I think, is that some law enforcement agencies have used kind of the national security information as predicated to be unrelated to national security originally. But the issue is then they're hiding the origin of the cases from the judges and the defense attorneys. So I was wondering, when you guys looked at this and when it's been before Congress now, I mean, there were some guardrails put in place. Do you think law enforcement has kind of jumped those guardrails or are operating outside of those guardrails? And if they are, what can we do to kind of bring that back together?
I do think they've jumped the guardrails, and the Congress, this committee in particular, is going to have an opportunity next year to take up reform of Section 702. That's a very important provision in FISA that allows the gathering of information about non-citizens outside the United States. But incidental to that, lots of information is gathered about U.S. citizens, and that information is then shared with U.S. law enforcement agencies, particularly the FBI. We think that there are not enough guardrails to require that the FBI show probable cause before they tap into that database to examine the information that they have at hand. So that's an opportunity to take up in the future. Another way around that has been for law enforcement and other government agencies, by the way. We're not just talking about law enforcement agencies. We're talking about almost any agency of the federal government and almost any agency of a state or local government to buy information. And that's the subject of the Fourth Amendment's Not for Sale Act, which we've heard a lot of bipartisan interest in here today, which I think is a very good thing.
Thank you. Thank you very much. Mr. Tolman, I wanted to direct a question to you as well. CBP and ICE have spent literally millions of dollars on contracts with data brokers like Ventel and LexisNexis. You know, these contracts are intended to help the agencies enforce immigration laws, but, you know, there's a concern now, I think, among many members of Congress that somehow this information is being gathered on American citizens and being collected. And I'm just wondering if you wanted to comment on that, or, you know, certainly that's a concern, even if you can't verify or underscore that it's actually happening.
Yeah, no question it is happening. No question that these brokers are you know, the amount of data points that they're able to gather is enormous. And keep in mind that you are also dealing with a situation in which the government, whereas in times past, they might have had a fingerprint database that came as a result of someone being arrested, and then they have a database full of that, or DNA evidence of suspects that were brought in. And that's very different than regular citizens of the United States, which have much of the data that could be pointed towards them, and sometimes falsely point towards them for commission of a crime. And so we should be concerned, and we have to be very concerned that the robust nature of the databases that are being purchased by our government agencies.
Yeah, and I think one of the other issues is kind of this lackadaisical kind of approach. And I think any American citizen who's not really in tune to this is, you know, I have nothing to hide. Who cares if they gather this information and you know, box it up and put it into some kind of data set? You know, that's another concern that I think Congress has to address. What are your thoughts on that as well?
Yeah, I 100% agree. All of my family believes TikTok is very innocent and fun and the most enjoyable part of their day. And yet we're watching just, you know, the potential for our privacy rights to be violated at enormous levels. And so I hope Congress is our last hope to fix it.
Very good. Thank you.
Thank you very much. I now recognize Ms. Ross.
Thank you, Mr. Chair, and thank you to all of our witnesses for being here. The Fourth Amendment is supposed to protect Americans against unreasonable searches and seizures. However, the Fourth Amendment remains dangerously undefined in the wake of technological advances, and we've discussed that for several hours here. Today, it's nearly impossible to avoid technology, and therefore nearly impossible to avoid the consequences of using technology, including the availability of personal data getting into the hands of interested parties. The Supreme Court recognized this reality in 2018 in the Carpenter case, which found that the government must obtain a warrant supported by probable cause to access cell site location information of more than 7 days in most circumstances. In its decision, the court noted that the services, cell phones, that are so pervasive and that they are an insistent part of daily life, and that carrying one is indispensable to the participation in modern society. More recent cases have also extended Fourth Amendment protection to personal data. Earlier this year, Judge Hannah Loke ruled in the Chatry versus U.S. case that law enforcement's use of Google location data to find people near a scene of a 2019 bank robbery violated the protections guaranteed by the Fourth Amendment.
She noted her deep concern that current Fourth Amendment doctrine may be materially lagging behind technological innovations, and emphasized the analysis of geofences does not fit neatly within the Supreme Court's existing reasonable expectation of privacy doctrine as it relates to technology. Notably, both the Carpenter and the Chattree rulings highlight the fact that users often do not consent to the surveillance they find themselves under, or they consent once when setting up their accounts without recognizing the amount of personal data that can be accessed from their phones for years to come. While some laws, including the Electronic Communications Privacy Act of 1986 and the Privacy Act of 1974, have attempted to provide some degree of protections, and we have had some later attempts, the last attempts are older, include loopholes, and they allow government authorities to buy private data from data brokers without a warrant, as we've discussed. We clearly need a better understanding of the extent of Fourth Amendment protections in the digital age and new standards for ensuring consumers comprehend how their data can be used. I'd like to ask, I know we only have 2 minutes left, each of our witnesses to say what one change they would ask Congress to make in evolving Fourth Amendment jurisprudence that would make a difference in the daily lives of our constituents. And I'll start with Ms. Goyetin, since she looked like she was thinking, and then we can move along the way.
I'm conflicted. Do I have to pick one?
Well, I'm sure somebody will pick the other one.
There's the long term and the short term. I'm sorry, I'm fighting the premise.
Pick two. Go ahead.
In the short term, Congress should pass the Fourth Amendment is not for sale act. That will go a long way toward closing the loopholes in existing laws, and those loopholes are what are allowing the government to buy its way around the Fourth Amendment. Then I would, or actually, frankly, at the same time, I would begin the project of comprehensive data privacy regulation, because we need it. We need laws that limit what information companies can collect, how long they can store it, who they can share it with, and what kinds of consent they need to share it.
Okay, Chairman Goodlatte.
Well, following along the lines of protecting our Fourth Amendment rights, I would call attention to something we haven't talked much about here today, and that is the fact that when the FISA court issues warrants allowing for the surveillance of various parties that are brought to the attention of the court, almost always there's only the government there making the argument that they should have the opportunity to do the surveillance. I think there are a number of circumstances, particularly when civil rights, religious organizations, political campaigns, and other important things are being involved in surveillance, that there ought to be somebody not representing the target of the investigation, but somebody representing the public's interest in protection against unlawful searches and seizures. I know you have taken an interest in that legislation. Congressman Stewart has. In the Senate, it's known as the Lee-Leahy or Leahy-Lee amendment that was offered to FISA a couple of years ago, and I think that would be a very important contribution. But I agree with Liza. Number one right now would be to pass the Fourth Amendment. It's not for sale act.
It's up to the chairman whether the other...
A brief answer by the other witnesses, please.
Sure. In addition, of course, to everything that that Chairman Goodlatte and Liza just said, I'd also ask everybody to take a look at the Privacy Act of 1974. I'm an administrative law professor, so everything for me goes back to administrative law. But that law is actually based on something called the Fair Information Practice Principles, which give a lot of kind of due process requirements, like transparency and notice and consent requirements before massive data collection happens by the federal government.
Ms. Wexler, short answer.
Thank you. Require law enforcement to obtain exculpatory evidence on behalf of the accused if defense counsel is unable to obtain it directly. This is a much bigger problem now that law enforcement is getting so much more data from the private sector rather than seizing or searching it directly, in which case law enforcement would in the process of collection, gain exculpatory information about flaws in the data or the method. But if they buy it from the private sector, they don't get access to those flaws. And so Congress should impose some obligation on law enforcement to gain possession of exculpatory evidence and hand it to the accused.
Mr. Tolman?
I agree with the FISA reform, the warrant reform, and the privacy reform, and I would add that you empower the Inspector General over DOJ with more authority and capability to go after abuse when it occurs.
Thank you, Mr. Chair. For your indulgence, I yield back.
Thank you. The chair now recognizes Mr. Stubbe.
Thank you, Mr. Chairman. My questions are for Mr. Tolman. The FBI has purchased thousands of licenses for software to canvass social media postings. In April of 2021, FBI agents mistakenly raided the home of an Alaska couple in search of Nancy Pelosi's laptop from January 6th. This raid was partially because of bad or misleading information that they garnered from social media postings. Beyond the obvious privacy implications related to mass collection of online data, does the practice also lead to sloppy law enforcement and mistaken identities?
There's no question that the use and the over-reliance on massive databases has produced great injustices, whether it be from the targeting of political adversaries to the misidentification among persons of color to you name it. So the abuse is very prevalent and it's growing, but I would just caution members of Congress that we only know the tip of the iceberg in terms of the abuse because we do not have enough transparency to understand it fully.
Well, and kind of along those lines, it's been widely reported that January 6 defendants have received increased sentences and harsher treatment based on the political views that they expressed on social media posts. They aren't being punished for just their actions, but also for the beliefs that they held. Some have even been subject to increased sentences for daring to question the legitimacy of the 2020 election. Presumably, some or many of these posts were found through social media canvassing programs discussed in this hearing. Does this level of government surveillance open the door to government persecution based on ideology? And Mr. Fitzgerald kind of hit on some of the FISA issues you saw in the Russia collusion hoax that we dealt with. If you could comment on that.
There is a great potential when utilizing all of the data points that are now being collected to actually work in reverse than what we think a traditional investigation would be. And that is to analyze the evidence and then pursue a particular target. Instead, what is happening is a target is identified and then they reverse engineer the evidence that is necessary to justify their investigation. That's a problem, no matter who's in power. It is a problem for abuse.
And I just want to, in the time that I have remaining, just kind of get your opinion generally on the Patriot Act, and I'll kind of set it up with a couple of examples. There's specific reasons why Democratic members of Congress and Speaker Pelosi herself have called Republican members of Congress domestic terrorists. And the reason for that is they then can use the Patriot Act to surveil on people that are deemed domestic terrorists. I'm aware of situations where Republican members' staff who happened to be in or around the area on January 6th because they work here, were randomly picked up because the FBI were using the technological capabilities that they have and marking as to whose cell phone numbers were here and then randomly asking them to come and have questions from them. What is generally your perspective on the Patriot Act and the abuses that we have seen occur? And again, to your point that you just made, we really will not know the depth of all of those abuses until we have full transparency from the FBI and the DOJ, which we're obviously not going to get, certainly under this administration. But I would like to know generally kind of what your feeling is on the Patriot Act and the abuses that we have seen where they use the term domestic terrorists to surveil on individuals like Trump collusion hoax and FISA and that sort of thing to surveil on the American people.
Well, there's no question that when the Patriot Act was passed and reauthorized in 2005, representation from Department of Justice and the FBI was that it would not reach and extend to citizens of the United States. That was with respect to most of its provisions, especially those that we hear so much about. You take delayed notice search warrants, for example. We were told that they would rarely request much of a delay in giving notice that they were searching a target's person or place or surveilling them. We learned later through the Inspector General that that was not the case, that Congress had been misrepresented to on its use. That abuse, I'm certain, has not stopped. Those that have that power need to be reined in. If not, they will continue to utilize the tools that are given them.
Well, and to your point, we're never going to know until there's transparency and documents, and the DOJ and the FBI are going to hide behind ongoing investigation or that type of thing to not give Congress the answers of what's really going on in these investigations. So absolutely, Congress needs to act as it relates to all of these programs and the surveillance and all of these things related to this. So I want to thank all the witnesses for their time here today. I yield back.
Thank you very much, Mr. Stubbe. This concludes today's hearing. We thank all of our witnesses for participating. Mr. Chairman, welcome back.